Pronouncement of judgment, item number 42, ISA Bill 537 of 20 in FAO 42 of 19, and item number 43, FAO 41 of 19.
IA dismiss. Appeals remanded to the learned trial court. Next.
Item number 44, criminal petition 706 of 2022.
Petition dismissed.
Item number 45 and 46, WBC 4353 of 23 and WBC 3035 of 23.
Both the petitions allowed.
Mention if any.
My lord, may I pray for listing one matter on 28? Because there is some urgency. I filed IA for fixing the case of hearing also. That has also not come, my lord. 2017 matter, long pending matter.
So how many times you have mentioned it?
No, this is for the first time because I have filed an IA for fixing the case of hearing also. That has also not come. Much.
Item number 36, my lord. The engaged counsel is out of a station and the matter may kindly be adjourned.
Thirty-six.
36, my lord.
For the appeal being made by Mr.
M. Pandit.
Learned counsel appearing on behalf of Mr.
M. Pandit.
Learned counsel for the appellant.
Appellant.
Places shall list the matter after
After 2 weeks.
2 weeks.
Much again.
Yes.
May I please, your lordship? My lord, I beg to mention item number 10 of today's daily list, my lord. Item number 10, my lord. My lord, kindly pass over the matter for the day, my lord.
The appeal being made by Mr.
Petitioner, my lord, on behalf of B. Kaushik, my lord.
Learned counsel appearing on behalf of Mr. B. Kaushik, learned counsel for the petitioner. The matter stands over for the day.
Okay.
Milord, AB Milord, which is rejected by your lordship, a second petition. So it may come on 26 or 28. Any date, Milord, 2 days. Okay.
Yes.
May it please support. Your lordship, I beg to mention item number 6 of the daily list. With the consent of the other side, your lordship, the matter may be adjourned for the day. The main counsel for the petitioner is not well today.
You are appearing on behalf of
The petitioner, your lordship.
petitioner. Your good name, please.
M. Das.
Ms. M. does learned counsel for the petitioner with consent from the other side. As for adjournment of the matter for the day, prayer stands allowed.
Obliged.
May I please, your lordship? Your lordship, I beg to mention one RSA for listing lordship in orders column
Where
on Wednesday, lordship.
28.
May it please, your lordship. So I am praying for listing of a matter for hearing, lordship, MSc appeal.
Where
Any date in the first week of April.
May it be please, your lordship? Lordship, I beg to mention for listing one MFA matter. It's a old pending matter in the year of 2015. Lordship, any date in next week?
for hearing.
Yes, lordship.
Okay.
Any date? 24. Obliged, your lordship.
Lordship, I'm mentioning 2 civil IOs, Lordship, for posting on 26th, Lordship.
Next week.
This week. Next.
Take it. Yes.
Lordship, I beg to mention item number 23. I am for the appellant, but I'm seeking adjournment on behalf of respondent petitioner since he is out of station for some medical reasons and we have consented to it, Lordship.
Your good name?
L.A. Magar.
Ms. L.A. Magar, learned counsel appearing on behalf of
R.K. Bhadra.
Mr. R.K. Bhadra, learned counsel for the respondent with consent from the other side.
We are for
Uh,
the appellant, Lordship, but we are for the appellant. R.K. Bhatra is for the appellant, but we are seeking adjournment on behalf of respondent claimant, respondent petitioner, Lordship, since he is out of state.
No, you are appearing for,
I'm appearing for the appellant on behalf of R.K. Bhatra.
learned counsel, appearing on behalf of Mr. R.K. Bhatra, learned counsel for the appellant, with consent from the other side. You inform the other side.
I'm for the appellant, and the other side, they have called us. He said he is not able to appear today because of some medical reasons. So he have asked us to seek adjournment on his behalf, and we have consented to it. Yeah,
The matter is that adjourned for the
for the day, Lordship.
day. Okay. Yes.
May please your lordship, I beg to mention one RSA and one IA in CRP for withdrawal, lordship.
When?
Any date, lordship, tomorrow, day after tomorrow.
Okay.
Apply.
May I please, your lordship, I'm praying for listing of an FAO. It was fixed on Friday last, but could not be listed because the bench was not available.
When do you want?
Either tomorrow or on 1st of April, my lord.
Tomorrow is hearing day,
Friday,
1st of April.
1st of April, my
Okay.
lord. 20. No, I'm sorry. Lot of days, 1st of April.
May you please your lordship, I beg to mention for listing of one RSA.
When?
Wednesday, lordship,
In which column?
admission. Bless.
Number one, Osman.
May it please the lordship.
Yes.
Lordship, I beg to mention item number 16, lordship. This matter is infructuous, lordship. Item 16, lordship.
Your good name?
D. Roy, lordship.
D. Roy. Mr. D. Roy, learned counsel for the petitioner submits that this CRPIO number 238 of 2023 become infructuous. And as such, the same may be closed. Accordingly, CRPIO number so and so such closed.
Obliged, lordship.
May I please your lordship? With the case, your lordship was placed earlier, pleased to reject his bail application, your lordship.
What is the new ground?
Lordship, two things, your lordship, we wanted to place, your lordship. First of all, your lordship, in the meanwhile, charge framing order of charge has been passed, your lordship, and in that order, your lordship, 409, your lordship, for which there is a conviction of more than 10 years, your lordship, that has been removed so far as the present petitioner is concerned. Now only 420 remains, your lordship. And secondly, your lordship, we have placed all the statements under section 161 of CRPC, your lordship, which in my humble submission, your lordship, will show that, your lordship, in fact, there is no direct material against the present petitioner.
Mr. Bortakur,
Lordship.
I'm not sitting in appeal
Lordship,
in
lordship,
the earlier order.
lordship,
If you have any grievance, you go to the proper place.
no, your lordship, that is there, your lordship, what is
Yes.
followed from your lordship's mouth.
Now,
but-
what is the ground you show me?
Your lordship, only that two grounds, your lordship. One is, your lordship, that the charge framing order has been passed, your lordship. When your lordship has taken up earlier, your lordship, 409 was there, your lordship. But now, your lordship, only 420 remains, your lordship, so far as the present petitioner is concerned.
That's all right. You have been granted liberty to approach the trial court. You approach the trial court.
That your lordship's order, your lordship, it is there, your lordship, but so far as your lordship, the present case is concerned, your lordship, and the second part is, your lordship, this, your lordship, the 161 statement, your lordship, which we have, your lordship.
No, you cannot be allowed to hesitate on that count. You cannot be. Because earlier we have considered it.
But your lordship,
No. This court has
that
no
was not
reviews
placed
jurisdiction.
from the side of the petitioner, your lordship, that's.
This
Yes.
court has no review power in criminal matters.
And Bath sect has also been removed so far as the present. Two sections have been removed, your lordship. That's the need.
You go and approach the trial.
Otherwise, your lordship, in fact, your lordship, to directly bring him within this particular sections, your lordship, that he has been.
Then why this bail application, you challenge the order, search framing order?
No, that search framing order, your lordship, we are preparing that, that's there, your lordship, but at the same time, your lordship, in fact, your lordship,
No,
since.
you tell me what is the new ground for filing this application?
Lordship, that what I have been submitting, your lordship, that your lordship, one is your lordship, that before, after passing of your lordship's order, your lordship has considered all aspects at that point of time, your lordship. But your lordship, then your lordship, for this framing of charge order is not there, your lordship, by which your lordship 409 has been removed, your lordship, 40 to 420 remains, your lordship. It's a 7 years conviction, your lordship. Even under your lordship, if 420 is there, your lordship, even during investigations, going by the principle laid down by the Honorable Apex Court, we are not required to be arrested, your lordship. That's one ground, your lordship, which has at that point of time.
You go and edit the trial court then.
And secondly, your lordship, that ground which I want to place, your lordship, that if from the materials they have placed, your lordship, will kindly see my bank account has not been seized, your lordship, and nothing, proceeds of crime is not.
In bail application, we are not supposed to consider all those things. It's a Borthakur, this is not a revision petition.
No, your lordship, I know, your lordship, that's what has fallen from your lordship. But that particular aspect,
No,
your
no.
lordship, that is not probably, since that has not been pointed out to this honorable court, your
No,
lordship,
no,
at a relevant point of time, going by the, what has been stated in the honorable court's order, your lordship. These are the two grounds.
What
Your
the
lordship.
IO has did and what the IO has not did, this court is not entitled to examine at this stage. You go and agitate the matter before the trial court.
Only for that purpose, your lordship, since your lordship has passed an order, your lordship, we came before this, come before this honorable court, placing these new facts, your lordship, news developments, your lordship.
No, these are not new development.
Because your lordship, the order
New development.
of the learned trial court, your lordship, was not before this honorable court at the relevant point of time. Your lordship, that's
That
and
is,
409, your lordship clearly shows, your
You
lordship.
have already granted liberty. You approach the
Lordship's
trial.
order is your lordship.
Yes, Mr. Sharma, what is? your-
Yes, my lord, that is in 108 page number, my lord. Your lordship clearly indicated in the last para, my lord, that liberty is granted to approach the learned trial court for examination of the two crucial witnesses.
That's what your lordship. And your lordship, that's why we are before this honorable court, your lordship. Placing that, your lordship, 409 after removal of 409, your lordship. And the fact that there is nothing in the search sheet, your lordship, which shows that I have received proceeds of crime, your lordship. In absence of these two crucial materials, your lordship. At least your lordship may call for the record, your lordship may kindly see, your lordship.
No.
Because ultimately, your lordship, it is the subtle principle of your lordship that at the relevant point of time, 409 was there, your lordship. Even your lordship, Satinder until case, your lordship, in category of cases, your lordship, where the punishment is less than your lordship 7 years.
You file a revision petition against the search framing order.
That
then
your
we
lordship,
will
we are
consider it.
preparing, your lordship, by next week, we are, then your lordship may, your lordship, take it up along with that, your lordship,
Okay, then.
keeping the matter pending, your lordship.
Heard Mr. Borthakur, learned counsel for the applicant, no, for the accused, and Mr. Sharma for the learned additional PP for the state respondent. Mr. Borthakur, learned counsel for the accused, submits that after dismissal of the earlier bail application by this court, the learned trial court had framed charge against the present accused, and that order is being challenged in this being challenged in a revision petition, and therefore Mr. Borthakur submits that this petition may be adjourned for the time being and to be listed with the aforementioned revision petition. Fair is accordingly allowed. List accordingly.
Deeply obliged, your lordship.
May please, your lordship. This transfer application is, my lord, for transfer of proceeding of FC civil case number 638/24 from the court of learned principal judge family court to the court of my lord district judge Lakhimpur, my lord. The petitioner is the wife,
Where the case is pending?
my lord.
Where the case is pending?
My lord, the principal judge family court, Kamrup Metro, Guwahati, my lord.
Kamrup.
My lord.
The petitioner resides at Kamrup.
No, my lord. Petitioner is the
Lakhimpur.
Lakhimpur. Wife,
And
my
the
lord.
respondent?
Respondent is Guwahati. Ground is, my lord, no sufficient income, my lord, and being a my lord woman, my lord, she could not accompany any male persons, my lord, to come to Guwahati to contest the case. And in earlier
Then
proceedings,
what is this? The proceeding is pending here.
yes, my lord, conciliation.
Conciliation.
Yes, my lord, on 23/4/25 next day.
Okay. Lord Mr. R. Sharma, learned counsel for the applicant. This application under section 22 of the Code of Civil Procedure is preferred by the petitioner for transferring FC within bracket civil case number 638 of 2024 from the Court of Learned Principal Judge Family Court number 3, Kamrup and Guwahati to the Court of Learned District Judge Lakhimpur at North Lakhimpur. Mr. Sharma, learned counsel for the petitioner, submits that the FC civil case number 638 of 2024 is instituted by the respondent,
My lord.
who happens to be the husband of the present petitioner, and that the present petitioner is residing at her native place, North Lakhimpur, and it is difficult on her part to appear before the Court of Learned Principal Judge Family Court at Kamrup, and as such, the FC civil case number 638/2024 may be transferred from the Court of Learned Principal Judge Family Court number 3, Kamrup at Guwahati to the Court of Learned District Judge Lakhimpur at North Lakhimpur. The submission of Mr. Sharma, learned counsel for the petitioner, needs further consideration. At this stage, notice to be issued to the respondent, returnable in 4 weeks, step be taken by registered post with AD and also by usual process, we can wait from today. And is there any interim period?
Yes, my lord. Further proceed. Page 15.
And Mr. Sharma submits that till disposal of this petition, further proceeding of FC civil case number 638 of 2024 may be stayed. We are taking note of the submission of learned counsel for the petitioner, and also considering the facts and circumstances on the record, this court is inclined to stay further proceeding of FC civil case number 638 of 2024 till disposal of this petition. Please stop your votes.
Obliged.
Item 3,
Wait, please, your lordship. This revision petition is directed against on being aggrieved by the order dated. Lordship will find the order at page 58. First order is 5824, in which I had prayed for, as the defendant, I had prayed for amendment of the written statement. Lordship will find the first order at 5820, dated 5824 at page 52.
Your prayer was not entirely rejected by the learned trial court.
No, lordship, but part of the order was prayer was rejected.
Whether part of the order can be amended.
Lordship, the trial court has noted that I am of the view that the veracity of the document in which the
Okay,
petitioner relies is doubtful.
We will issue notice.
Lordship will just note that in this part of the order, what I had prayed for was for to bring in that document so that I could prove my possession. And lordship knows that mutation is
Okay, we
based
will
on
issue
possession.
notice at this system.
Further, I pray for stay, lordship.
Let the other side appear. We will consider your interim here. Or Ms. B. Soduri, learned counsel for the petitioner. This petition under Article 227 of the Constitution of India, read with Section 151 of the Code of Civil Procedure, is prepared by the petitioner for correction, alteration, modification. So how can this court correct, alter, or modify the order of the trial court?
Lordship, under
This
115,
petition
your
ought to have been
lordship,
filed before the trial court.
lordship, under 115, your lordship has that power. Revision jurisdiction. This petition may
Order
be-
dated 19/12/2024, passed by the learned civil judge junior division number 2, Sipsagar in Mizji case number 71 of 2024, between bracket TS 45 of 2023. Arising out of the order dated 5/8/2024, passed by the learned civil judge junior division number 2 in Mizji case number 33 of 2024. There is the petition and the documents placed on record, and also there is the impugned order dated 19/12/2024 and 5/8/2024. Let notice be issued to the respondents, returnable in 4 weeks, step be taken by registered post with AD and also the usual process with from today. List the matter after 4 weeks. Interim care of the petitioner will be considered after appearance of the other side.
Supplementary list, item number 47.
Lordship, there is a typographical error. I may be allowed to correct it.
In this petition.
Yes, Lord.
Item number
Three.
104.
Item 3.
No, madam, there is a procedure. You have to follow that procedure. You have to file one I.
I'll do that. Much obliged. May it please your lordship. In this case, lordship, the petitioner says the plaintiff's lordship. Their PW1 was closed and thereafter all further evidences were closed and then argument was also closed, lordship. First order, impugned order dated 30/1/2025, annexure 5, lordship.
What is your grievance in this petition?
Lordship, the suit has been fixed for judgment tomorrow, lordship, by closing my PW1 and argument also. So my first order, your lordship, will find annexure 5, lordship. 76 page, lordship.
Order dated?
31/2025. Plaintiff filed a petition number 6.
Trial court has observed that the court cannot permit endless adjournment as it is bound to ensure the efficient administration of justice.
But lordship,
How many adjournments you have taken there?
lordship, in 1 year, maybe one adjournment, but due to some other reason, my cross was not taken. First of all, I was cross-examined partly on 2 dates, lordship. For further cross-examination, 3rd date was fixed, lordship. Thereafter, entire records were called by the appellate court, and then after 2 years, records were again transferred to the present court. Thereafter, the proceeding started, lordship. So, lordship, on annexure 6, your lordship will find I have filed another application after recovering from my illness, lordship, that I, Abdul Khalik, plaintiff's witness, is present today before honorable court on last 31/25 due to my illness, and adjournment prayer was made on my behalf. But honorable court closed the further cross-examination of PW1 after rejecting the prayer and fixed next day.
Tomorrow is fixed for judgment.
Yes, lordship.
Today this court.
Lordship, last order was passed on 6/3, lordship.
No.
Lordship, I have some decisions of
No,
that
no,
if an
maybe
adjournment
you
was
may
given,
have several decisions.
Lordship,
But,
I have
the
filed
given
this
facts
case
and
on
circumstances,
19/3. Thereafter, a mention was made for listing, lordship.
No.
Lordship, kindly consider
No,
that
sorry.
all the villagers clubbed together to file this suit,
No,
lordship,
no.
praying for their right of path, lordship. At least one chance, lordship,
No,
one
no,
date
no.
may be given. I will, at least my argument may be considered, lordship. My argument, that was also, lordship, rejected. Prayer for argument, lordship. That petition was also rejected. 31, my first
No,
petition
no,
was rejected.
you see the order dated 6/3/2025. In the last part, it is mentioned that plaintiff is at liberty to submit his side of argument before pronouncing judgment. You go and argue the matter.
No, Lordship, by written argument.
You go and file the written argument.
Lordship, there are two other plaintiff's witnesses are there.
No,
Lordship,
no, no.
PW1 was already
Sorry,
cross-examined.
sorry,
Only one chance, Lordship.
sorry.
I'm relying on the judgment of this court and
No, no,
Supreme
no.
Court also, Lordship. If adjournments were granted, those may not be considered during the further prayer of adjournment, Lordship.
We are
And in
dismissing
this
the
case-
petition, yeah, but liberty is upon you to withdraw this application. Whatever you like.
Lordship, in that
Tomorrow
case-
is fixed for judgment and today we'll grant this thing.
No, Lordship, I have
Huh?
filed it on
While you
19/3,
have-
6/3 last order, Lordship.
You have taken endless adjournment before the trial court.
No, Lordship, only 3 adjournments, Lordship, in 3 years, but 2 years,
Now
the
you tell
entire
me
records.
whether you pursue the matter or you withdraw this application.
Lordship may pass order, Lordship. I have
Okay.
no instruction to withdraw the matter, Lordship. Unless Lordship kindly see the 6/3 order was obtained certified copy on 10/3. Accordingly, we have filed on 19/3/25, Lordship. And thereafter a mention was made before your Lordship to list this.
Ms. R. Sodori, learned counsel for the petitioner. In this petition under Article 227, read with Section 151 of the Code of Civil Procedure, the petitioner has challenged the correctness of the order dated 30/1/2025 passed by the learned civil judge, Junior Division Ceremony in title suit number 1 of 2017 by closing further cross-examination of PW1 and also the order dated 28/2/2025 passed by the learned civil judge, Junior Division, and also the order dated 6/8/2025 passed by the learned civil judge, Junior Division. Whereby the petition filed by the petitioner for reopening the evidence of PWs was rejected.
On 6/3, another application was filed. That is annexure 9, page 82, Lordship.
And also, so by the same order, that petition was also dismissed.
Yes, 2 petitions were dismissed on 6/3/25, Lordship. One is 425 and one is 426, Lordship.
The learned counsel for the petitioner submits that the matter is listed tomorrow, that is 25th of March 2025 for judgment. And that the learned trial court has dismissed the petition filed by the petitioner for reopening the evidence of PWs. And that the petitioner may be granted one chance to adduce evidence. And that the learned trial court has also not allowed to file a written argument by the petitioner. And therefore, Ms. Chaudhary, learned counsel for the petitioner, contented to grant one opportunity to the petitioner to adduce evidence. Having heard the submission of Ms. Chaudhary, learned counsel for the petitioner, I have gone for the order dated 30/1/2025,
28/2, Lordship.
28/2/2025, and 6/3/2025. It appears from a fair perusal of the aforementioned orders that sufficient opportunities were afforded to the petitioner to adduce evidence, but the petitioner failed to avail the same. And further, it appears from the order dated 6/3/2025 that the plaintiff is granted liberty to submit his side of argument before pronouncing the judgment. And in that view of the matter, I find the submission of Ms. Soudary bereft of merit. And accordingly, this petition is dismissed.
I'm deeply obliged, Lordship.
Item 48,
Lordship, I like to mention the page 66, Your Lordship, whereby this honorable court has, the trial court has directed to pay the amount of rupees, 10 lakh rupees with 5 installments, as well as the current amount to his daughter. Accordingly, I have paid all the things, Your Lordship, I have annexed all the order sheets. Now I have been affected with the annexer 23, Your Lordship, 97 pages. The next date is in 21. The whole my attachment of my property as well as movable property has to be attached. Since I am the supervising office.
Where is the impugned order?
97, Your Lordship, page 97. I am supervising of the metric as well as high secondary examination. I have also, my learned counsel, I have applied their Lordship, we have not received. They have turned down my application also. I have already paid 3,50,000 along with 70,000 with compliance of the honorable court order from time to time, Your Lordship. That has been narrated as per order sheets as well as in my page number 20, paragraph 24 and 25 and 26, Your Lordship. I have paid 3,50,000 as well as 3,20,000 page paragraph 26, 70,000 to my daughter. And this honorable court has, trial court has already observed my that I have been engaged in the supervisor of the high secondary and metric exams. In spite of that, giving a gap of 1 day, Your Lordship, they have passed this honorable court's order, which become a very much jeopardize in my career if it will be not being stayed, Your Lordship. And even though page 98, Your Lordship, she is a contractor, first class contractor, I have also an X24 page, annexer 24, page 98. After being a personal.
Where is the decree?
Lordship?
Decree?
Lordship,
Where is the decree?
Decree is on page 66, Your Lordship. Starting from the annexer 6, page 54. And relevant portion of 66, Your Lordship.
That is the judgment. I am asking about your decree.
Decree I have not annexed because the order sheet is there, Your Lordship, is page annexer 8, page 78, Your Lordship. In this execution case. And page 94, Your Lordship. The court has also observed page 94, Your Lordship, annexer 20. It is on a record, Your Lordship. He is a supervisor of high secondary and SLC examination, which is going on, Your Lordship.
No, for filing your reply, you are not supposed to remain present in the court. You can
Lordship, I
file
have
it
prep-
through your counsel.
Lordship, I had applied on 2025 to 2025, Your Lordship, but that have not been received. They have not admitted my petition. Court is pinpointing only that they give the money, one after another date, Your Lordship. I have applied and that
Yes,
have not,
your judgment date, you are to comply with the
I have,
order, whatever
Lordship, I had already,
is passed.
I give an application that I'm in the examination hall, Your Lordship. By to engage counsel, I have paid there, but that have not
Maybe
been,
in the examination hall,
this one is there,
you
annex.
can pay the amount through your counsel.
Yes, I have paid annex page 19, Your Lordship. I have paid 3,50,000 to my wife, Your Lordship,
No, that is not within the stipulated period by the court. When the decree was passed.
decree was passed on within the 10 days, within the 15 days. Now humble submission is
Within 15 days, and what was the stipulated period of payment of rupees 10 lakhs?
within 5 installments within
Within 5 months.
within
And the decree was passed on 16. Judgment was passed on 16/12/2023. How many years elapsed since then?
Lordship, within the 5 months I have to pay.
Then
Then I have also applied before the court that I
how
have
many 5 months elapsed in the meantime?
Lordship. That is there, Lordship. And I have also applied for that. I have also taken a granting loan, Your Lordship. In spite of my salary, whatever is there, I'm trying my best to give the amount. I have applied before this honorable court. I have no any intention to deliver negligence of this honorable court, sir.
No.
Whatever I have got it, Your Lordship.
Your
But the amounts,
your conduct seems to be not satisfactory.
the only point is that, Your Lordship, I'm ready to pay every year, whatever the amount is, but let this honorable court maybe only on that point, Your Lordship. My examination is going, at least I have to collect from my, even a paper leakage is also going on, Your Lordship, in this paper. It's also burden of proof, me also to inquire the matter in Lakhimpur district also, Your Lordship.
We will not grant any stay unless you furnish security.
Lordship may permit me to stay this order, and whatever this honorable court point me, I will do it accordingly, Your Lordship.
No. You have to first deposit the security amount.
Security, you have already paid, Your Lordship, 3,50,000.
No. Security before this court.
No, Lordship, I will pay. Issue is that 29 is the next date, Your Lordship.
Maybe.
29 is the next date, Your Lordship. It is very impossible for me, Your Lordship, because my whole, only one point, Your Lordship. I'm a government official and I'm a supervisor of the Lakhimpur and high secondary metric examination, Your Lordship. I have not been open, move out. On that point, Your Lordship,
No.
I have nothing to pay before this honorable court, Your Lordship. Only one point I have come before this honorable court to at least that day maybe after examination is over, I will pay I will undertake my statement, Your
So
Lordship.
to stay the decree, you have to pay the security amount before this court. Then where is the document of payment of rupees 3 lakhs?
It is there in the order sheets, sir. All the order sheets, it is there. I have annexed all the order sheets.
Order. In which order?
If you see that from 13.15, Your Lordship, all the order sheets I have been annexed here. First order is at annex 9, Your Lordship, page 80. 35,000 I have paid. Then, Your
Show me
Lordship,
the order where it is reflected that you have paid more than 3 lakhs.
it is there in the order sheets continuously, Your Lordship. One amount I have paid 26/7/2024. That order I have been shown at 35,000 to my daughter. Then 9/8/2024, 50,000 as a part payment, Your Lordship, first installment.
Page number?
Page number 80. Page number 80 is the 35,000 to my daughter, sir, after next day. Then, Your Lordship, 9/8/2024, I have paid 50,000 to my wife as a first permanent installment, as a first installment.
Page number?
Page number 81, your lordship, continuously, your lordship, 80, 81. Then 88, your lordship. I paid 2 lakhs rupees to my wife and 10 lakhs rupees to my daughter. Then, your lordship, 2/11/2024, I have paid 50,000. Then to my
No,
10,000
no. 2 lakhs rupees, you have paid,
to my permanent alimony.
where it is mentioned?
It is in 9/9/2024, page 88, annex 14, your lordship. All the consecutive orders I have reflected. By through these orders, I have total amount is 3,50,000 by the order sheets on our court's order. 9/9/2024, page 88, annex 14, your lordship. This is the
So,
amount.
you deposit 50% of the remaining amount
Lordship.
before the court. Only then we will consider this petition. Otherwise, no.
I'm intending to pay, your lordship, because
No. On that assurance, we cannot grant stay of the decree.
lordship, I will pay. I will have to pay start with my client
Okay,
at 2 o'clock, your lordship.
okay.
And deeply obliged.
Item number 40, item number 4.
May I please, Lordship, Lordship has passed an order on 19/2/25, Lordship.
An affidavit has been prepared and sent for vetting losses. So losses can fix the matter. From our side, we have prepared the affidavit and it is sent for vetting. So by next week, I will file the affidavit. And in so far as the provisional pension is concerned, the petitioner is getting the provisional pension.
You were getting the provisional pension.
My lord,
You were getting.
my lord. After this order, I have received. And my lord, there is a direction to finance, my lord. They have also supposed to file their affidavit, my lord. But they are always lingering the case, my lord. Lordship, may kindly peruse 2 earlier orders, my lord. Or-
Is Mr. Soliha available here?
He is present here.
Last occasion, he was present.
Today also he is present.
No, on the last occasion, in this particular matter, he was present.
He was present.
No, is Mr. Soliha present today?
Okay, today.
I have seen in the court.
Can you call him? So Soliha, have you filed your affidavit?
No, Lordship, Lordship, here what is happening is, Lordship, here my learned friend, he's asking for pensionary benefits and retirement benefits, Lordship. He, as per our instructions, he was appointed on ad hoc basis. So now, what my learned friend, he's, as per our, there was a proposal sent by the education department for regularization of his services. That was regretted by the department because he was appointed on ad hoc basis. So, and there were previous orders from these courts where it was directed that the petitioner should be given his arrear salary dues and whatever retirement benefits or pensionary benefits that he is entitled to. That pensionary benefits and retirement benefits has to be given by the parent department. So that is the limited stand of the finance department over here. A proposal was sent for regularization of his services. Lordship, as per his record, since he was appointed on ad hoc basis, finance has regretted that proposal. So now whatever dues is that is to be given to the petitioner, that has to be addressed by the education department.
They have been lingering the case, my lord, repeatedly, my lord. Let them file affidavit, my lord.
No, the petitioner also has to inform the court what all he is expecting from the court, Lordship. If he's expecting regularization, if he's expecting retirement benefits, that has to be specified with the petitioner also. As we have a limited, Lordship, if we go through the prayer of the petitioner.
No, Mr. Soleha,
Lordship.
by order dated 19/2/2025, you have been asked to file your affidavit
My
in
lord.
opposition. You file your affidavit.
Lordship, but our stand is a very limited.
No, that's all right. Whatever you have taken your stand, you bring on the record by filing an affidavit.
Lordship, then Lordship will grab me 1 week's time. I'll file my affidavit in that.
Yes.
It's a very small stand which we have.
Then Mr. Soleha.
Lordship, prior to passing order, two early orders, my lord. Order dated 23/6/22.
No, that's all right. Let their affidavit.
My-
come. Because you are getting the provisional. pen.
My lord.
Third, Mr. D. Bora, learned counsel for the. Then Mr. A. Soleha, learned standing counsel for the finance department. Then Mr. Sorma for respondent number 1, 3, and 4. Then 5. Then Mr. L. Gogoi, learned counsel appearing on behalf of Mr. C. Bora for AZ. Respondent number 7. Mr. Sorma and Mr. Soleha submits that they may be granted 1 week time to file their affidavit in opposition. Here is accordingly allowed. Rest is the matter of.
Lordship, Lordship, immediately after the vacation, Lordship, I'll just, because we have to file immediately, Lordship, may fix it on 21st also, Lordship. I'll just,
No, your rule is very limited.
yes, Lordship,
You to that extent you can file affidavit before vacation.
Lordship, that can be,
7th of April.
Lordship.
7th of April.
My lord, affidavit as a last chance, my lord.
No further chance will be given
Lordship.
to Mr. Sorma and Mr. Soleha to file their affidavit in opposition.
And my lord, others respondent may file if they desire to
In
file.
the meantime, the other respondents may also file the affidavit in opposition.
Obliged, ma'am.
Item number 5.
May it please the lordship. So the petitioners preferred is petitioner lordship paying for area salary for a particular period lordship. There is July 2019 to February 2021 lordship. And Lord, it is admittedly true that he was suffering from tuberculosis lordship. And thereafter, after recovery lordship, COVID-19 has begun lordship. And Lord, for that Lord, they have filed an affidavit. Lord, that was not conclusive at all. But Lord, I have filed my reply. Kindly have a look at page 53 of my reply, Lords. Annexure A3, last page, Lords. Affidavit in reply, Lords.
Page number?
53, Lords. As if second last paragraph, Lordship. Page 53.
Yes. Page number?
Page number 53, Lords.
53 is annexure.
Annexure, Lords.
Yeah.
It's a letter from Lordship, Director of Elementary Education to the District Elementary Education Officer, Golaghat, Lords.
Yes.
Second last paragraph, Lordship, of that paragraph, last line, Lordship. It is seen that without regularization of absent period, how the teacher concerned was allowed to join and release his salary, Lordship. And accordingly, he was once again requested to conduct an inquiry, Lordship. But Lord, their affidavit is silent about that, Lordship. Hence, my Lord, my limited prayer is that, Lordship, the matter may be reverted back to the Director, Lordship, to conduct an inquiry as to why he is entitled for the area salary or not, Lordship. Because, my Lord, he will be the right person to decide, Lordship. Because Lord, at that point of time, Lordship, COVID-19 was there, Lordship. The school was remain closed, Lordship, at that point of time, Lordship.
Then what was the reply of the district elementary education officer?
Lordship, the report which the district elementary education officer through the BEO, my lord, if your lordship sees page 40, there, my lord, in our affidavit, my lord, we have said that he was on tuberculosis leave from 5/1/18 to 36/19 at page 40 of our affidavit. Paragraph 6.
No, that is your statement, but where is the letter of the district elementary education officer?
That is, my lord, next one, my lord, page 42.
Is it page number 43, annexure 1?
My lord, this is the paravise which has been given to us. We have annexed that.
No, annexure 1
Yes, your lord.
of your affidavit.
Annexure 1, my lord, page 42 and 43.
Submission of detailed report.
Detailed report, madam. The office caused an inquiry through BEO Golaghat regarding the arrear salary claim. And the same thing is given here, my lord, that's why, in the main petition. He was, my lord.
Is this letter is the reply of the letter dated 19th of June 2023? Annexure 83 of the affidavit in reply.
Perhaps not, this letter is regarding this writ petition, lordship.
It's
Subject
not
is
the
that-
reply of this annexure 3.
Lordship, no.
A-
Subject
A3.
is that, lordship, submission of detailed report and parawise comments on WPC so and so, lordship.
Yes, this is the basically the, my lord, the report which we have said, my lord, and in the page 40, my lord, we have clearly stated, my lord, in on note by that he has been working for, he had taken tuberculosis leave from 5/1/18 to 36/19. After availing that, my lord, he instead of joining duty, my lord, from 36/19 or 30, my lord, he remained unauthorizedly absent from duties from 1/7/19 to 7/3/21 without any intimation to the concerned authority. And my lord, moreover, my lord, he is claiming that at that point of time the COVID was there. COVID actually started from March 2020. Because if your lordship sees 36/19, that time the COVID was there. March 2020 only the COVID started officially. Your lordship recalls. So that is the statement we have made, my lord. And therefore, my lord, from 8/3/21 he again joined. So from then he is getting his salary. So the question of getting arrear, my lord, is also, my lord, is disputed, my lord. That's why.
And my lord, kindly have a look at page 26 of my writ petition, lordship. It's a lordship certificate issued by National TV Control Program.
Mr. Pokan. So where is the reply to this letter of 19 June 2023 written by the director to the district elementary education officer Golaghat?
This must be this is a letter written from the which the petitioner has annexed. This is regarding clarification of area proposal in respect of the petitioner of St. John. This is in 19 June 2023. If you look, see 19 June.
The last paragraph.
Yes, and after that, my lord, the affidavit which we have filed, the affidavit we have is dated which is page 42, annexure 1, that is 27/12/2024. So that is the detailed report in which it is there. So going by this report, this is the latest that we have, my lord, subsequent to what he has filed. 24. 23. What we have annexed is the latest, my lord. Detailed report. It is mentioned in the detailed report also, my lord, that after availing TB up to 36/19, he remained unauthorizedly absent from duties.
What is your submission in this regard?
So kindly have a look page 26, lordship. Page 26 and its type copy is at page 25, annexure 6 of my writ petition, lordship. It's a certificate issued by lordship, medical officer TV control Golaghat, lordship. This is to certify that Sri Chandrakanta Sharma, aged about so and so,
Page number?
page number 25 type copy, and page 26 is the lordship in vernacular lordship. It is written that as per certificate of treatment with effect from 8/2000, and he is fit to resume his duties with effect from. He was treated for TB lordship till 29/2/2022 lordship. 29th of February 2020.
For how many days? 239 days.
39 days lordship. Even my lord,
And the period for which you have not received the salary?
since July 2019 to February 2021. Right? Because my lord, since March 2020, perhaps the school was remained closed for COVID-19 lordship. The school registers will speak for itself, lordship, but my lord, even my lord, going by the submission of my learned friend, lordship, their affidavit, kindly have a look at paragraph 5 of their affidavit, lordship, page 39, what they have said, lordship.
Paragraph 5.
Lordship. That the deponent, instead of giving paragraph-wise reply to the writ petition at this stage, deems it appropriate to disclose the stand of the department against the relief sought for in the writ petition. However, the deponent craved leave of this honorable court to file a detailed paragraph-wise affidavit. As if their affidavit is not at all conclusive, lordship, right now, lordship. But
My
they
lord,
have
it
not
is
filed-
conclusive, my lord, because of the fact that the period for which he was absent, my lord, that is he was unauthorizedly absent. So that period he has not received any money, and the detailed, my lord, the report, the inquiry which was conducted, the detailed report is annexed over here, my lord, which has been submitted, my lord, to the director. There, my lord, it has been categorically stated that that the lordship comes to the main report again, my lord, the 24, the latest one which we have annexed, page 42. The lordship comes to from bottom, my lord. My lord, 8th paragraph, my lord. After availing TB leave, my lord, up to 36/19, he remained unauthorizedly absent from duties with effect from 1/7/19 to 7/3/21. He was served notice by the BEO concerned, asking him to join his duty. White letter dated so and so, dated 3/9/2020. He had to resume his duty immediately after availing TB leave up to 36/19, but he remained unauthorizedly absent from duties with effect from 1/7/19 to 7/3/21 and resumed his duties on 8/3/21. As reported by the BEO, his salaries has been released with effect from 8/3/21. So therefore, my lord, we have done the right thing because he was absent from that time. We have not given him that money, and from 8/3/21, since he has joined back, from then we are releasing his.
No, this certificate he produced before the certificate at page number 25, annexure 6. Indicates that he was suffering from TB.
Yes, and my lord, he has joined in
My lord,
school lordship on 5/5/2020. I have annexed the joining report, page 52, lordship, of my affidavit. Running,
And lordship,
it was sent to-
TB part we are not denying. TB he was, my lord, he had taken leave, and that too, my lord, from which period to which period we have given the disclosure also. So he was on TB leave, my lord, on his own request from till 36/19. So the question arises after that, where was he for that period? From
No, my lord,
36/19
on 5/5/2022, he has joined lordship, page 52.
my lord, 36/19, he remained unauthorizedly absent from duties with effect from 1/7/19 to 7/3/21. So that is the moot question, my lord. Why he was absent that time unauthorizedly, and therefore, my lord, since he has joined back on 8/3/21, after that, my lord, we have released his salary. So now he cannot claim that, my lord. That,
No.
because no work, no pay, my lord.
Have you seen the affidavit in reply?
My lord.
He resumed duties on 5/5/2023.
And this joining was sent to the lordship BEO. So, post 50. Well, even though, my lord, we go by the submission of and lordship, director is yet to take a decision on the report, lordship. He has not taken any decision, lordship, after the detailed.
Which report?
Lordship, assume we have, assuming that, my lord, this is the report submitted by as submitted by Mr. Fupon, that letter, annex, page 42 is the detailed report, Lordship, submitted by the district elementary education officer, Lordship. But Lord, after that report, Lordship, the director is yet to take any decision, Lordship.
Then my lord can remand it back to the director also. Let them give a reasoned order, looking at all the, verifying all the details. And giving him a patient hearing, if that be the case.
Because Lord, it is admitted that he has joined on 5/5, 5/5/2020, Lordship.
Because that part also, my lord, is disputed. We will have to verify. So let it be remanded back to the director. Let the director verify, give him a patient
So
hearing.
thereafter, if we remand the matter to the director, again, same thing will happen.
So my lord, if at that point of time, he can convince that he has joined, my lord can, because it is pending, he's saying, my lord. No?
No, there is an endorsement of the headmaster also in page number 53.
Otherwise- Otherwise, my lord, can I take instructions regarding page 51? Whether he has joined or not, regarding that.
Page number 53.
52, sorry, ma'am, 52.
52 type,
Copy.
51.
So regarding whether he has joined or not, that part.
No,
because I have
this
got-
certificate was given by the headmaster. Where is the point for disbelieving it?
No, my lord, but let us check the records, man. Sometimes nowadays, man, there's no seal and signature, man, proper. This second page, if you see, Lordship sees seal and signature also is, so let the,
No, what the action was taken by the director on the basis of this letter?
initially, my lord, that time in the.
That director district elementary education officers letter dated 27/12/2024.
My lord, there, my lord, the 27/12/24, my lord, the report is there, my lord, annexed here, wherein, my lord, an inquiry was conducted, he was given show cause to appear, I have read it out now, my lord, beforehand. Submission of detailed report and parawise. So detailed report is already given here, he had inquired, my lord, as reported by the BEO, my lord, kindly see, after availing all that, my lord, after availing PB recall, he remained unauthorizedly absent from duties from so-and-so, he was served notice by the BEO concerned asking him to join his duty by letter dated so-and-so, dated 3/9/2020. He had to resume his duty immediately after availing TB leave up to 36/19. But he remained unauthorizedly absent from duties with effect from 1/7/19 to 7/3/21 and resumed his duties on 8/3/21. As reported by the BEO, his salaries have been released with effect from 8/3/21. He is not entitled to any salary for period from 1/7/19 to 7/3/21 as per FR 17/1 as he remained unauthorizedly absent for that period. Submitted for fine cancel. So this is there, man. This is the inquiry we just conducted. Detailed. This is the report which I have annexed in the affidavit, which is at page 42, which clearly states that he had not worked from 1/7/19 to 7/3/21. Therefore, that salary was not he does not, because of no work, no pay coming in, my lord. And later on, my lord, when he joined from 8/3/21, his salaries have been given. Now the question is, my lord, he's saying that he joined from 2020.
5/5/2020.
5/5/2020. So regarding that, my lord, we'll give at least 1 week time. I will, in the meantime, contact the director because I have been served a copy recently, my lord, in this reply. So I will ask that particular specific instruction I'll ask.
When did you receive the
That day,
copy of 53, page number 53?
that
When?
this reply I received today, my lord, he has given me a copy.
At the time of filing, we have already served the copy. They have not kept it properly. We don't know, but I have given it myself. Lordship.
Again today.
No, my lord, he has not given me. Must have given someone else, but I have not received it. I received it today only. But I have gone through and I have conducting the.
Heard Mr. Coupon, learned counsel for the particular, and Mr. Dave Coupon, learned standing counsel appearing for the respondent in elementary education department. And Madam 4, respondent number 4. Respondent number 4. Having heard the submission of learned counsel for both the parties, and also taking note of the letter, joining letter of the petitioner dated 5/5/2020. It is provided that Mr. Kupang learned counsel for the respondent authorities and persons so shall obtain necessary instruction as to whether the petitioner has joined on 5/5/2020. Please the matter on 1 week. 1 week. Third of April. Please the matter is parted.
Item number 7.
So this is the regular first appeal also. But suit is for specific performance of contract. And the Learned Court below has rejected the prayer for specific performance of contract. However, the alternate prayer has been allowed. Against that, this appeal has been filed. And while deciding the issues, and the main issues has been decided in favor of the plaintiff appellant. But by citing some unrelevant factor, refused to grant the main prayer law.
Third, Mr. Data, learned counsel for the appellant. This appeal under section 96 of the Code of Civil Procedure is deferred by the appellant, namely Ashok Kumar Mittal, challenging the correctness or otherwise of the judgment dated 10/12/2023 and the decree dated 17/12/2023 passed by the learned civil
24.
senior division 6 cyber in title suit number 7 of 2022. Is to be noted here that by judgment and decree dated so the learned Dalford has partly decreed the suit. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned judgment and decree dated 10/12/2024 and 17/12/2024 respectively. Admit, issue notice to the respondents returnable in 4 weeks, submit taken by registered post with AD and also by legal process within. Rest shall call for record from the learned trial court. List the matter after 4 weeks.
There is a IA lordship for injunction lordship.
That notice go at this.
No lordship, if they alienate the property to any other third party, then third party
No,
right
is
will.
there any chance for alienation?
Yes, lordship. Therefore, this IA has been filed. In the before the lower court, there is an injunction. I have annexed the order lordship in the suit. Page 31 is the relevant. Last,
In which paragraph of your petition you have mentioned it?
but in the alienation lordship,
Yes.
I have annexed. Paragraph 10 lordship. Page 12.
That is only apprehension.
Yes, lordship. They can because they are in possession of the property lordship. So therefore, alienation part may be injunction lordship.
Let notice go at this.
That either status quo lordship, because they are in possession. The property is a building lordship. So if the alienate third party right is created, then it will be difficult for us lordship. Status quo lordship.
Where is the document to show that earlier there was injunction?
That in the IAL I have annexed lordship.
Page number?
Page number 31 is the relevant lordship. Lordship good. Last paragraph.
31 of this IA or?
IA lordship. IA lordship prior court injunction order has been annexed. last paragraph.
Heard Mr. Deca, learned counsel for the applicant. This application under Order 39, Rule 1 and 2 with Section 151 of the Code of Civil Procedure is prepared by the applicant for granting
Page 15.
ad interim injunction restraining the respondents, their man and agent, employees, assignees, or servants from changing the nature and character and feature of the suit property, from alienating the suit property to any third party by whatsoever means till disposal of the connected appeal. Mr. Deca, learned counsel for the applicant, submits that the applicant has instituted a title suit
7/2022.
being title suit number 7 of 2022 before the Court of Learned Civil Judge, Senior Division, Shivsagar. Hearing the respondents herein for a degree of declaration, compensation, specific performance of contract of agreement for sale dated 25/5/2021, and also to grant permanent and mandatory injunction and for other reliefs. In the said title suit, the applicants had also filed one application under Order 39, Rule 1 and 2, dated Section 151 of the Code of Civil Procedure, for ad interim temporary injunction restraining the opposite parties and all other persons claiming under and through them for selling and for transferring the ownership of the suit property in favor of any other person except the petitioner. And upon the said application, the learned trial court has registered Ms. J case number 03 of 2022, and thereafter by order dated 10/4/2023 was pleased to grant temporary injunction in favor of the present applicant. And that after the trial, the learned trial court has granted alternative relief as sought for in the said title suit, and that against the said judgment and decree dated so and so, the applicant that has preferred one regular first appeal being RFA number 15 of 2025, wherein this court was pleased to admit the same and also pleased to call for the record, and that there is a requirement for directing the parties to maintain the status quo till disposal of this petition, as there is chance for alienation of property by the respondents by creating third party interest. Having heard the submission of Mr. Data Learned Counsel for the applicant, I have carefully gone to the petition and the documents placed on record. And also perused the judgment and decree dated so and also the order dated 10/4/2023, passed in Mijay case number 03 of 2023. It appears that the learned trial court in the said Mijay case number so was placed to grant temporary injunction till disposal of the suit. And taking note of the submission of learned counsel for the applicant and also considering the facts and circumstances in the record, this court is satisfied to hold that there is a requirement for directing the parties to maintain status quo till returnable debt. Accordingly, it is provided that the parties shall maintain status quo as on today till returnable debt.
Highly understood.
Document release, item number 49.
May it please your lordship. My lord, this appeal has been filed against the judgment dated 4/1/2025, passed by the Employees Insurance Court, Dibrugarh, in ESI case number 1 of 2022, whereby my lord dismissed the petition filed by the appellant under section 75G of ESI Act, my lord. The case of the petitioner is that, my lord, he was a contractor, he was having a, my lord, proprietorial firm, which is dealing with supplying of, my lord, ground staff to the Indigo and Jet Airways, my lord. And he obtained ESI registration in the year 2003, and he was paying regularly the contribution till the year 2015, my lord. And my lord, on 17/12/2015, my lord, his security clearance was cancelled by the Ministry of Aviation, my lord. And that was communicated to the station manager, Dibrugarh, on, my lord, 5/1/2016. And accordingly, my lord, his contracts were terminated by both the airways, my lord. And since then, he could not obtain, my lord, any contract, my lord. And regarding cancellation, he has already, my lord, communicated the ESI authority, my lord, immediately. And in the year 2022, my lord, in the month of February, he received an order, my lord, under section 45A of ESI Act from the, my lord, respondent number 1, my lord, whereby demanded, my lord, rupees 5,19,750 as area contribution for the period, my lord, January 2017 to, my lord, September 2021. Thereafter, my lord, petitioner visited the ESIC, my lord, and apprised the fact that he has already abandoned, my lord, entire contractual work, my lord, since after 2016, my lord. And respondent number 1 also, my lord, assured not to proceed further, my lord. But he has received another notice, my lord, dated 10/5/2022, issued by the recovery officer of ESIC, my lord, whereby, my lord, demanded rupees 7,19,397 and directed to pay within a period of 15 days. And accordingly, my lord, the petitioner filed an application before the ESI court, Dibrugarh, under section 75G of ESI Act, my lord, and in which, my lord, after receiving the notice, the respondent authority has appeared and filed their written statement, my lord. And in the written statement, my lord, it was stated by the respondent, my lord, the declaration for ESI registration was not submitted by the petitioner for specific work that the stand taken by the petitioner in the petition that is supplied, my lord, ground staff for Indigo and Jet Airways. And therefore, my lord, cancellation arises only on permanent closure, not for termination of contract. That was their stand. And it was also stated in the written statement, my lord, that prior to passing the order under section 45A to Show cause notices were issued on 23/11/2021, whereby opportunity of hearing was given to the petitioner, but he did not appear before the ESI authority, my lord.
Okay, let notice go at this stage.
But my lord, I have also filed an IA, my lord, for stay of the recovery proceeding, my lord. Because I have, in earlier, my lord, before the law,
What was the amount?
my lord, now, my lord, 7,19,397, my lord. And
So for staying the order, you have to furnish the security before this court?
yes, my lord, because in ESI court also, we have deposited 25%, my lord, when it was stayed, my lord. Now it was returned back, my lord. We are ready to pay, my lord, that amount.
Pardon, Mr.
UK does,
Learned counsel for the appellant.
my lord.
This appeal under section 82, which in bracket 2 of the Employees State Insurance Act 1948 is directed against the judgment and order dated 4/1/2025 passed by the learned Employees Insurance Court Dibrugarh in ESA case number 1 of 2022. It is to be noted here that by reviewing judgment and order dated 2022, the learned
Yes, I could dismiss the petition, my lord, and by the present appellant, my lord.
the learned Employees Insurance Court Dibrugarh has dismissed the ESA case number 1 of 2022. By holding that the appellant herein is not entitled to any relief as claimed by him, and thereafter dismiss the application filed under section 75 within bracket 3 of the ESI Act 1948. There is a memo of appeal and the grounds mentioned therein. This appeal is admitted on the following substantial question of law. 1. So this substantial question number 1 will serve the purpose for it.
My lord,
Whether the learned
my lord, 3
Court
is
below.
also relevant, my lord.
Heard in law by holding the order under section 45 as A of the Employees State Insurance Act 1948 dated 24/1/2022 passed by the Deputy Director and authorized officer, Employees State Insurance Corporation as justified in absence of any inquiry report under section 45 of the ESI Act 1948 or proof regarding functioning of the appellant's petitioner's firm after 2015 and verification of identity of the beneficiaries.
My lord, 3 is also relevant, my lord, because it will decide the, my lord, whether principles of natural justice has been complied with or not, my lord.
And number 2, whether the learned court below is justified in holding that the appellant petitioner was provided reasonable opportunity of being heard as required under first proviso to section 45A of the ESI Act 1948. In absence of any proof regarding delivery of notice to the appellant petitioner before passing the order under section 45A dated 24/1/2022. Issue notice to the respondent, returnable in 4 weeks. Step be taken by registered post with AD and also by legal process if you may wait from today. Justice will call for the record from the learned trial court. In IA, you take down heard Mr. Das learned counsel for the applicant.
I am praying for stay of the annexure 4, my lord. That is demand notice dated 10/5/2022, my lord.
No, we will stay the order of the impugned judgment and award, impugned judgment or this
My lord,
impugned notice.
notice may be stayed, my lord, because my application has already been dismissed, my lord. And there was stay of this application, this notice, my lord, in the trial court below, my lord.
What section 83 of the act provides
My
for?
lord. Stay of the recovery proceeding, my lord. Stay of payment pending appeal, my lord. Is 54 most probably.
This application under section 83 of the Employees State Experience Act 1948 is preferred by the applicant for staying operation of the impugned. Operation and execution of part number ESICP 2, within bracket, notice of demand to defaulter, hearing number hearing number 43 00 again 003876 00 01001 stroke CP stroke 260232 stroke RRC dated 10/5/2022 issued by the recovery officer any region employees State Insurance Corporation arising out of the order under section 45A of the ESI Act dated 24/1/2022 passed by the Deputy Director and Authorized Officer employed the State Insurance Corporation. Mr. Das, learned counsel for the applicant submits that the applicant had prepared an appeal against the judgment and order passed by the learned ESI Court Dibrugarh. Then the said appeal has already been admitted and notice has been issued to the respondent and the record has already been called for. And till disposal of the appeal, there is a requirement for staying the notice of demand to defaulter.
That should be my lord, annex of
Dated
4.
10/5/2022, annexure 4, that page number 17. No, page number 19.
19, my lord.
Page number 9. Till disposal of this appeal, and the applicant is ready to deposit
25%, my lord.
only.
Within 2 weeks, my lord.
No, only.
25% on the, my lord. 7,19,397, my lord. That is the amount, my lord, specified in the, my lord, the demand letter dated 10/5/2022, my lord. Kindly see page 19, my lord, below.
Subject to deposit of 25% of the amount before the registry of this court within a period of 2 weeks from today. In terms of this IS transpose.
Okay.
So let it be listed before the court.
My
then.
lord,
2 times.
though my lord,
Twice.
my lord, it cannot be my lord expressed, my lord, in open court, my lord.
Acha, cannot be.
My lord.
Okay, okay.
So my lord, that's why.
So this is a regular second appeal.
Yes, my lord, against the.
So what are the substantial questions
Yes,
of law?
lordship will find page 4, B, C and D, my lord. page 4, my lord. B, C, and D, my lord. C is the main important, my lord. My lord, I am the plaintiff, my lord, in this suit. Suit is, my lord, for declaration and for permanent injunction, my lord. I have lost in both the courts below, my lord. My lord, the lordship will find the, my prayer in the plain page 12.
Page
12.
yes.
My lord, should the decree declaring that the plaintiffs having long possessions over the suit land and their possession cannot be disturbed or taken away by the defendants number 1, 2, 3, 4 by taking law into their own hands. Should be decree declaring that the plaintiffs' long-standing possessions of the suit land cannot be disturbed, they cannot be forcefully dispossessed except under the due process of law. The plaintiffs' possessions of the suit land be confirmed. Now, lordship will find the WS filed by the defendant. It starts at page 15. Relevant
Page?
for 15. Relevant portion, lordship will find page 17, paragraph 11. Page 17, my lord, paragraph 11. May I read, my lord? That the statements, averments, and allegations made in paragraph 3 of the plaint are completely false, frivolous, and concocted. That it is denied that the plaintiffs have been possessing the suit land as before. That the plaintiffs are simply a dear opposite of the opposite party defendant number 1 for just only 3 years, who used to do only seasonal cultivations of paddy crops and also gave 2/3 share of paddy crops to the opposite party defendant number 1. That it is also denied, got prepared, Cloutons. I have skipped that part. And in the last, my lord, 5 lines, my lord, from bottom, that being the adhere of the suit land, the plaintiffs also informed about the transaction, so and so, so. My lord, here the defendants have admitted the plaintiffs as an adhere. Now, lordship will find page 34, which is a part of the, my lord, trial court judgment.
Page number?
Page, my lord, 34. It's a part of the trial court judgment, my lord. Third paragraph, my lord. That the defense have admitted that the plaintiffs were adhere in respect of the suit land, but the defendants have denied the claim of the plaintiff that the plaintiffs are in possession of the suit land for last 20 years and they are still in possession of the suit land. Further, the plaintiffs have failed to prove that they are in possession of the suit land at present. The initial burden upon so and so, so and so, so and so. My lord, here, though, my lord, the defendants, it is an admitted fact that they have admitted the plaintiffs as an adhere, my lord. But the learned courts, as both the courts below, my lord, while deciding the, my lord, suit as well as the, my lord, first appeal, my lord, have not considered the protections which I am entitled, my lord, under the Assam Temporary Settled Areas Tenancy Act. And that, my lord, in the evidence part also, my lord, I have specifically pleaded that I am the, my lord, being the, my lord, adhere of the suit land. I am specifically pleaded in paragraph 4 of my evidence that the defendants in the written statement filed in this suit specifically admitted our
Page
position.
number?
No, my lord, that is not on part of the memo of appeal. It is in evidence.
Have you enclosed that evidence?
No, my lord, that I have not enclosed because the records is necessary, my lord. That's why, my lord, my
No, is that
substance.
certified copy of the evidence?
That is not certified copy, my lord. It is not. So my first substantial question of law, my lord, is C, that I am entitled, being an admitted fact that the defendants have admitted in their WS, it need not require to be proved, my lord. Being an admitted fact, page 17, paragraph 11, that I am the adhere. So I am entitled the protections provided under the Assam Temporary Settled Areas Tenancy Act 1971. So that part, the courts below has not considered, my lord. C.
Mr. Gogoi?
I'm for the responder one. Firstly, in the plaintiff or in the first appeal, they have not taken the plea of adhere. in the WS, the respondent has said 20 years ago, he was in possession. Both the court said he is not in possession. In the first appeal stage, they filed a petition under order 23 to withdraw the suit to file fresh. On the ground that they are not in possession, their application. And second, the defective boundary of the schedule. And third, non-necessary party. This one, page 56.
But my lord, that is not my substantial question. But my lord, before submission.
No, Sir Sharma, please.
Yes, yes, yes.
Page
Number?
6. Now the suit has become infectious because they themselves said that they are not in possession of the suit letter. Page 56, para 13. We shall first decide petition number so and so by which prayer for dismissing the title appeal number so and so on withdrawal with an opportunity to further withdraw the title suit number so and so from the learned trial court with due permissions to issue a fresh suit for proper relief has been made. From the pair portion of the petition number so and so, it is clear that plaintiff want to restart the title suit number so and so at the appellate stage. Peruse order 23 CPC which deals with withdrawal suit. Code of civil procedure by Sarkar 8th edition reprint 10. Page 1970 deals with that matter, which states that the grant of leave emphasis in sub-rule 3 of Rule 1 is at the discretion of the court to be exercised by the court with caution and circumcision. Clause B of sub-rule 3 contains the mandate to the court that it must be satisfied about the sufficiency of the grounds for allowing the plaintiff to issue a fresh suit for the same claim or part of the claim on the same cause of action. This becomes all more important in a case where plaintiff has application under Order 23 Rule 1 at the stage of appeal. Grant of in such a case would result in unsuccessful plaintiff to avoid the decree against him and seek a fresh execution of the controversy on a clean state. It may result in contesting the defendant losing of the controversy on a clean state. It must also result in the contesting of defendant losing the advantage execution of the dispute by the court or courts below. Grant of permission for withdrawal suit will leave to file a fresh suit may also result in annulment, pressured in the defendant or even a third party. However, it is been held in Dinabandhu Sahu versus Buddhi Devi so and so that withdrawal suit cannot be permission even by the appellate court. The relevant portion is page 15, paragraph 15. We have discussed the laws on the matter of withdrawal of the suit. Now let us go to the grounds on which the prayer for withdrawal suit was with permission to file fresh suit has been made. There are specifically 3 grounds: non-joint of necessary party, defective description of area of the suit land, and forceful occupation of the suit land by the opposite party. In para 2 of petition number so and so, it has clearly stated that the patadar of the scheduled land is joint pata holders and number of co-patadars are 85 for a long covering 28 because 19 lesser. But thereafter it has been stated that 85 number of co-patadars has got respective share of their land for lawful partition, and so the co-patadars are necessary party. When the appellant plaintiff is stating that the joint co-patadars have partitioned the land, the plaintiff has burden to prove the partition, any such partition of land has been made, then the co-patadars are not necessary parties. On the contrary, if partition was not made, the plaintiff in the original suit was bound to make them as parties, but what he has not done so. Therefore, the assertion of the appellant plaintiff, the co-patadars are necessary party on the one hand, and they have partitioned their land on the other hand, a rival assertion of his does not coincide. Therefore, the assertion of the plaintiff is not reasonable. Hence, such prayer cannot be granted. The second ground for withdrawal is the defective description of the area of the land. In para 3 of petition number so and so, it has been stated the suit land duly scheduled below by mistake mentioned 2 figures, 0 kathas, 0 lessers. It is an arithmetical mistake, creating as formal defects to the suit of the applicants. But in the schedule of the petition number so and so, again plot of land mentioning 2 figures was provided, is similar to the schedule of the plane. Therefore, plaintiff have failed to tell any variance, and he specified the land as 2 figures everywhere. Therefore, the assertions of the plaintiff side are not true. Appellant plaintiff in para 5 told the defendants forcefully entered the suit land on 12/6/23 after dismissal of the suit by learned trial court. Therefore, this is the occurrence after the judgment passed by learned trial court. Therefore, the petitioner are not entitled to rectify the claim which has been filed for a prior occurrence. Thus, we see the grounds specified in petition number so and so are unclear, vague, untrue, apart from the being unreasonable. Thus, it is clear that the petition has been filed only with the intention to deserve food or decree to the decree holder by seeking a fresh education. Hence, Paris number is rejected.
this is the heir file. So their main prayer in the suit was they are in long possession and they cannot be affected. This is the prayer. From their petition itself that they are in possession, but the trial court and the first appellate court has said they are not in possession of the suit land because they failed to prove that they are in possession. And in the case of Adhyar, what they see now, in the first bill, not a single advertisement was made by them that they are there. Yes, they are already Adhyar 20 years back, not now.
In the written statement, it is stated that they were the adhere.
Adhyar once, not at the time of filing the suit. Your lordship may see the written statement. Yes. Page 17, para 11. That statements, amendment, and allegation made in para 3 of the plain are completely false, fabulous, and concrete. Yet it is denied that the plaintiff has been possessing the suit as before. That the plaintiff has simply adhere or opposite party defendant number 1 for just only 3 years, who used to do seasonal cultivation of paddy crop and also get 2/3 of the paddy crop to the opposite party number 1. This is also denied. So once they were adhere, not at the time of filing of the suit. And there is no any plea or any payment of rent. There is a one judgment of this Honorable Body High Court when the Assam Temporary Settled Areas 1971 Act will come into force. This I have given the judgment earlier. Controversial Culture 2017 SSC online Guwahati. Then here in the pair 20 in the record.
Para
20 of the judgment. When this act will come into force, applicable, sorry. There is judgment in the past of judgment in there. Sandhar Kulta versus Rohit Kulta. Lordship got it?
No, Mr. Gogoi, unless a question is framed on that point, this court cannot decide the issue.
No, in the plain, my humble submission, in the plain or in the there is no mention that they are the adhere in the entire
That's all
plain.
right, but unless a substantial question of law is framed on that point, this court is not entitled to appreciate the evidence.
They have not given any evidence of rent receipt, or there is no any from the revenue authorities. They are the adhere, or they have the khatian. They have not given anything. This is pair 20 he said. When the act is applicable, only that point, only one point. When the act will be applicable, because in the first appeal in the plain there is no mention. Nothing. If your lordship see, there is no mention of anything. They are simply the possessor. They have paid. They have the hara of the responder 1. So they should not be evicted. And their decision on property also it is wrong. They claim 2 bigha, but it is 1 bigha. In the plain, if you see, there is no mention of anything. Not a single word in the plain or in the first appeal. No grounds taken.
Let us admit the appeal. We will hearing on the substantial question of law. We will frame only one substantial question of law, whether the first appellate court. No, whether the finding of the first appellate court in the MPM judgment suffers from any perversity due to non-consideration of the protection entitled by the appellant stroke plaintiffs under the some temporarily settled area tenancy act 1970.
Issue also not framed.
Pardon?
Issue was also not framed, but trial court.
May not be, we will see.
And Lordship will consider one thing that this case filed for not to evict them without due process of law. In the appeal, they have said that we are not in possession. They are different. What the suit remains because they are not possession. They have not because they are claiming the land on the basis of possession. In the appeal, they filed a petition that they are not in possession.
That's all right. Unless we admit the appeal, can we hear you on the fact? Only we will frame only one substantive question.
Lordship, please see one prayer 20 of the prayer 20 Honorable Kolda.
Now, para 20 you have already shown me.
The prayer 20 of the judgment. Honorable Kolda versus Rohit Kolda.
Which one?
Honorable Kolda versus Rohit Kolda. Seven SSC online Guwahati 1381. Para 20, only one paragraph. Married?
Para
20. Considering the summation of both the learned counsels, it is very much surprising that both the courts below came to a conclusion that the defendant number 3 is a occupancy tenant and that too under the Assam Temporary Settled Areas Act 1971. When there is not even an iota evidence in support of Khatian issued by the competent authority in favor of defendant number 3 or defendant number 2, the status of occupancy tenant, the declaration of status of occupancy tenant, and his entitlement to claim the benefit under the Assam Temporary Settled Areas Act 1971 is well within the ambit and scope of the civil court to decide. But the same must be proved as per a requisite qualification stipulated in the said tenancy Act 1971 for a person to fall under the category of occupancy tenant. The defendant appellant never even pleaded with regard to the rent, the nature of the position of defendant number 2 and 3, and mere carrying out cultivation for more than 3 years, and 2 without any recognition by the revenue authority to any of the defendant number 2 and 3 as arrived. There cannot be any applicability of the tenancy Act 1971. So far as the present case in hand is concerned, according to the justice.
Mr. Gogoi, this judgment was passed by this court.
Yes.
After framing a substantial question of law.
Yes, yes.
Right?
Yes. Yes.
But in the present case, can we do so without
because
framing the
they are not given any land receipt and all. You will see that they are trial court judgment.
Mr. Gogoi, okay, we will consider your submission.
Because in the trial court judgment, they have exhibit 2 documents: the certificate of the community and the revenue paying receipt of the land, not the rent of the as for the Khatian and rent. And there is no any Khatian in this regard, no exhibit anything. Page 36 of the trial court judgment. What exhibits they have given is there.
Page number
36. Exhibit 1, hard copy of the issued by the Mojadar, 10 affidavit issued by the defendant number 1 and 5 are the signatures. This no any khatian, no any rent receipt and all.
No, exhibit 229 are revenue paying receipt.
These are the annual revenue paying, not a khatian, annual revenue paying. Revenue
But there is a receipt of revenue payment.
revenue payment because they have another pot of land nearby. Another pot of land nearby. They're paying the revenue receipt of that land, not this land. The revenue paying is not a khatian rent, not a rent receipt. Rent receipt is something different. This is revenue paying. Hazana. Yeah. I got the documents.
Huh? Artifact của việc thực hiện. Artifact của việc thực hiện.
This annexer one was given by the Mojade.
Yes. Pretty much another land in the same patta. They have another land in the same patta. These are the receipts of that land.
What is the basis of such submission?
You stated in the WS.
Mr. Sharma,
Paragraph 9, page 16, we have stated. Page 16, para 9, bottom part. Para 9, 4 lines from the bottom. Father so far, Lossy got it? Para 9. Father so far, the paying the land revenue is concerned, the 21 is the owner of land measuring 1 biga covered by document number so and so, and on the stand of said facts, he used to pay the land revenue of the photoshoot patta. Here's another problem. They purchased from me from the father of the respondent one. They purchased earlier.
no, that is your statement made in the written statement.
Also in the
There,
also he has admitted all these things.
no?
Cross examination.
Mr. Sharma, under which provision of the Tenancy Act, you were entitled to protection?
51, my lord.
Pardon?
51.
80.
51.
51.
My lord. Fifty-one two. Any tenant not being an occupancy tenant shall not be ejected from the land of his tenancy except in execution of a decree of ejectment passed on any one of the following grounds. So far, my lord, the crops or rent is concerned, my lord. It has been admitted in paragraph, my lord, 11 of the WS itself, my lord. If lordship, so once again, my lord, read that paragraph. Paragraph, page 17, paragraph 11. So far, crop or rent, so far my learned friend is arguing, my lord. That is admitted fact. If lordship, once again, my lord, peruse the page 17 of the WS, my lord, paragraph 11, my lord. Page 17, paragraph 11, my lord. May I read, my lord, relevant part, my lord. That the plaintiffs are simply a heir of the opposite party, defendant number 1, for just only 3 years, who used to do only seasonal cultivation of paddy crops. This is one part, my lord. And also gave 2/3 share of paddy crops to the opposite party, defendant number 1. So crops, my lord, they have admitted that crops has been the defendant number has received from the my lord plaintiff. So far rent part is for using the my lord being a tenant, my lord, being an adhere. My lord, that is admitted. So an admitted fact, my lord, need not required to be proved, my lord. That is why, my lord, my substantial questions of my lord. See, my lord, that is
in village areas, the Adhi, we say one person cultivates the land, after 3 years, another person cultivates the land.
Yes,
It's not,
correct.
it's so, once, this is once, and in the plain, whole story is different. They say they are permissive position, not they are not.
Why they have admitted in WS
No,
if the story is different?
And the plaintiff has to prove his own case, not to bring with a witness or a defendant. No, the whole story is different in the plea.
Third, Mr. R. Sharma, learned counsel for the appellant, and Mr. Gogoi for the respondent.
Respondent number 1 only,
Respondent number 1.
the owner of the land.
This second appeal under section 100 of the Code of Civil Procedure is directed against the judgment dated 18/11/2024 and decree dated 3/12/2024 passed by the learned civil judge, Senior Division of Soraidio, Sunari, in title appeal number 2 of 2023. It is to be noted here that by the impugned judgment and decree dated so and so, the learned first appellate court has dismissed the appeal and affirmed the judgment dated 2/6/2023 and decree dated 3/6/2023 passed by the learned Monsif. Now, Civil Judge Junior Division, within bracket, Soraidio, Sunari, in title suit number 24 of 2021. Peruse the memo of appeal and the grounds mentioned therein. And also peruse the suggested substantial question of law. The second appeal is admitted on the following substantial question of law. Whether the judgment and decree passed by the learned first appellate court dated 18/11/2024 and the decree dated 3/2024 and also the judgment dated 2/6/2023 and decree dated 3/6/2023 passed by the learned Monsif. Soraidio, Sunari. Is perverse for non-consideration of the protection which the appellants herein are entitled to under the sum within bracket temporarily settled area bracket close Tenancy Act 1971. In as much as the respondents stroke defendants admitted that the appellants stroke plaintiffs as adhere in the suit premises. The court may also consider framing of substance not framing of further substantial question of law if found necessary at the time of hearing after giving notice to both the parties. Press shall call for the records from the learned courts below. So list the matter after for which.
My lord, notice to the my lord other respondents.
Pardon?
Notice to the other respondents, my lord.
Yes. Notice be issued to.
Two people.
Caveat is there. Caveat would be heard. Caveat stands to set.
Oblige, my lord.
Obliged. Number 9.
May I please? This second appeal, my lord, against the judgment and decree of reversal. Page 5, my lord, suggested substantive question of that.
First appellate court has prevailed beyond the pleadings of the party. This is the first ground, my lord. One, two, and three will.
So the trial court has dismissed the suit,
Dismiss the suit.
dismissed the suit, and
We
the
are-
appellate
we are-
court has reversed it.
Reversed.
Then appellate court has considered exhibit Go,
Yes.
which is not in the pleading.
Not. Here the case is there, the plaintiff's respondent hearing and the principal defendant number one. Principal defendant number one is the father of the plaintiffs. Their plaintiffs are the children of the principal defendant number one. And their case is that by dint of a power of attorney executed by principal defendant number one in favor of principal defendant number two. The principal defendant number two executed the sale deed in question. They never questioned the power of attorney. Only their case is that
Exhibit Go is the power of attorney.
power of attorney. Their case is that to declare the sale deed as null and void. Your lordship kindly peruse the page 52, prayer of the plaintiff. The suit be decreed in favor of the plaintiff declaring their right, title, interest and possession of the Schedule A land. Suit be decreed declaring registered sale deed mentioned in Schedule B as null and void and cancelled the cost of the suit, any other relief. So the basic thing is that the power of attorney by dint of and against another fact is that the against principal defendant number one, he has never appeared before the court. Despite due service of natives, the suit proceeded ex parte. And the power of attorney they have never. The another thing is the sale deed they have questioned. Here plaintiff 1 and 3 were the attesting witness.
Third Mr. Ayuddin, learned counsel for the appellant. This appeal under section 100 of the Code of Civil Procedure is directed against the judgment and decree dated 30/10/2024 passed by the learned civil judge senior division Huzai, Shimanta Nagar.
Now name has
in
been,
title appeal number 5 of 2022. It is to be noted here that by reviewing judgment and decree dated so and so, the learned first appellate court has allowed the appeal and set aside the judgment and decree dated 8/4/2022 passed by the learned monthly passed in title suit number 4 of 2007, by which the learned trial court has dismissed the plaintiff's suit with cause. Where is the memo of appeal and the grounds mentioned therein? This second appeal is admitted on the following substantial question of law. Whether the finding of the learned first appellate court suffers from perversity for traveling beyond the pleadings of the plaintiffs and deciding the suit on the basis of exhibit law. In bracket, a registered power of attorney number 137 of 2000 dated 29/5/2000. Executed by the principal defendant number 1 in favor of the defendant number 2, principal defendant number 2. The court may also consider framing of further substantial question of law if found necessary at the time of hearing after giving notice to both the parties. Issue notice to the respondents returnable in 4 weeks that be taken by registered post with AD and also by usual process within a week from today. The SSL call for the records from the learned courts below. Please the matter after 4 weeks.
I also noticed maybe issue. This state, since execution proceeding has not yet.
Issue notice.
I am obliged.
There are 2 IA.
One is disposal, one earlier disposal.
Oh,
It was
condemnation of delay.
for condemnation of bill.
Issue notice.
Obliged.
When have you responded, Lordship?
Whether this applicants are present, this IA?
Lordship, as per the last order, that is 39/2024, that they have filed 2 applications for setting aside abatement and delay condonation. But those 2 applications. 11.
May I please, Your Honor, kindly pass over the matter for day after tomorrow.
Why?
My senior instructed me.
Who is your senior?
Zay Ahmed.
Pardon?
Zay Ahmed.
Ms. So-and-so learned counsel for the applicant. Any objection?
Otherwise,
So
also
from the
those 2
other side,
applications
first
are
of all,
involved.
listing the matter, the right for adjournment of the matter for the day. Fair allowed. The matter stands over for the day.
Obligation.
Madam, service completed, madam, item 12. I
Completed.
have furnished the affidavit of justice service, madam. Justice service. Respondent number 3, madam. One and 2 is there.
You are for 1 and 2. One.
1, 2 is there. No. Jay Gogoi is there. Just wonder what his services are through justice service. I think that copy from justice service is not affidavit. It is in my hand, my lord. On 18/3/2025, affidavit is filed.
Okay, third, Mr. D.C. is open. Learned counsel for the appellant and Mr. Sik. Yes? Okay. Okay, for respondent number
One.
one. None address for the respondent number two. Office note dated 19/3/2025 indicates that notice upon the respondent number three was served by the stimul, and an affidavit to that effect has also been filed, which is tagged with the record as flag A. Perusal of the same reveals that notice was served upon the wife of the respondent number three. On 3/1/2025. Thus, notice deemed to have been served upon respondent number three, but respondent number three remain unrepresented today. So focus our next counsel for the appellant submits that service completed here in this case, and the records of the courts below have also been received. And as such, the matter may be listed for hearing. Accordingly, it is provided that recessal is the matter for hearing in usual course on a date to be fixed by the registry.
All right.
Lordship, I have taken instruction. He will ready to pay 50% of this honorable court within 15 days, your lordship. That will be around your lordship 3,15,000. And in the meantime, he has already paid 20,000 that have not been reflected in the order sheet. Otherwise, he have to pay 6,30,000. It will be half will be 3,15,000. Pay before this honorable court as a security deposit.
No, 50% of the difficult amount.
Already he has paid a 3,70,000, your lordship. So the remaining is around 6,30,000. 3,70,000 has paid, around 6,30,000 is wait, remain. Out of 6,30,000, it will be around your 3,15,000. 10 lakhs is the amount your lordship. And also I have paid my data also around 5,000 per year, and that I have already paid. I have no any deliberate negligence or no any.
Then why you have not been able to clear the amount?
Lordship, the amount
You
has
have
been.
granted only 5 months.
Lordship, that is the thing that I have also another responsibility. In there, if Lordship call for the records, you will find your Lordship how I have been regularized this job and what I have done. In her itself, in the judgment itself says that since his job is not regular, so we have not the file. After being your Lordship 10 years back, this execution petition has been filed. That is around your Lordship, I have mentioned 4,336 days. And since he is a class 1 contractor, I have also mentioned.
Who is class 1 contractor?
See, wife, my wife. Last page yourself. Annex 24, page 98.
No, that has already been considered.
That is already been decided. So my humble prayer is that I'm not being harassed in that way, Your Lordship. That the court has been passed within a single day. I observed that I have been not obeyed before this honorable court within 5 months. But that cannot be, Your Lordship, so much harsh to me, because my intention is very clear and I have paid since.
No, apart from that, 5 months, you have already been given several months.
Yes, Lordship, I have paid, Your Lordship, whatever I have, the salary which have been there, I have been paid. There is no any deliberate negligence.
Whether that payment is in terms of the order passed by the Lord Trial Court.
Yes, Lordship.
How?
We
You
have already.
Firstly, you have failed to make payment within five months.
That is the true, Your Lordship. 5 months is there, but I could not pay it. I have also mentioned that I have been bank loan. I have applied for the bank loan, Your Lordship. It has been there in the order reflected. Even today also, just now instruction that if he got a loan, then next day he will pay. Only humble request, Lordship, that 29 is maybe state and I may be allowed
You first deposit the amount before this court, only thereafter will pass the stay order. Otherwise not.
Yes, I am ready to pay, Your Lordship. Only the date is the 29. Otherwise, if my attachment will be done, then what is the remedy for me to before this honorable court? Otherwise, Your Lordship. Movable and immovable property repeatedly, Your Lordship. And mine, that my data is also now become measure. In spite of that, I have giving all the being as an teacher, I am done have whatever I have been received, Your Lordship. But the mere this type of so much harsh, Your Lordship, that also considered that they have one.
How it is harsh?
Your Lordship, I am trying my best. The moment the case has been filed, I have tried to give in. But salary is okay, but movable, immovable property. That is my humble prayer, Your Lordship. I leave it to the court, whatever this honorable court pass, I will take an oblige.
Under Article 227 of the Constitution of India is directly against the order dated 35/2024, passed by the learned district judge docket court. Under Order 21 Rule 11 of the Code of Civil Procedure. You have challenged this order 31/5/2024.
Subsequent orders all, Your Lordship. Only on the point, there's a 2 point, Your Lordship. I'm challenging the order subsequent to execution without the honorable trial court, without any filing any condonation delay that have been admitted. There is no any mention of how many days it has been condoned. That is a prima facie, there is a wrong in the part of the execution court. Even though I have paid, Your Lordship. That date is amount. That decree has been passed, Your Lordship. In my case, Your Lordship, the divorce petition has been filed on the 15/7/2011, Your Lordship. And the execution has been filed on, Your Lordship, 2021. This totally bad in law, Your Lordship, without filing and continuation petition. Page 22, Your Lordship, paragraph 3 ground, 3634 days.
And also the order dated 22nd of December 2023. Passed in meeting is number 1 of 2021. Where is that or this order? 22nd of December 2023?
Twenty is the last disorder here. Page 8, annexer 18, page 92. But they had filed on Your Lordship on 31/5. Your Lordship, page 67 is the or notice
you
order.
Come
First,
to your page number 2 of the petition.
Lordship.
This order dated 22nd of December 2023. In Tuesday case number 1 of 2021. Where is that order?
That order is notice 67, Your Lordship, page. Page 67.
Page
67. Mid-J case 1 of 2021. Nineteen one, 2001, 2021 is the order. First order.
Page 67.
Lordship, notice to the respondent.
But you have mentioned it as order. Not part of the record.
Lordship, I have the original certificate.
Where Mr. Gogoi learned it from the order. Petition.
Lordship, this is
Mr.
the
Gogoi, the learned counsel for the petitioner is directed to bring on record the order dated 22nd of December 2023, passed in mistake case number 1 of 2021 by the learned district judge Lakhimpur, not Lakhimpur. Place the matter on Wednesday. 26th.
deep level.
Next slide.
Deep level.
Lordship,
Yes.
this is an injunction application filed by the respondents. Lordship. I'm the respondent in the RSA 213 of the 2017. I filed a suit for declaration of right title and interest with respect to Schedule L and D. And part of Schedule L and is Schedule B and Schedule C. So Schedule B plus Schedule C is equal to Schedule A. So I sought for the relief of declaration of right title and interest with respect to entire Schedule L and with respect to Schedule B and for confirmation of poison and Schedule C and for recovery of poison. So my suit was decreed initially by the learned trial court. Sorry, decreed right title and interest with respect to Schedule L and confirmation of poison with respect to Schedule B and that those were allowed. But the relief with respect to Schedule C and recovery of poison that was not granted. On being appealed, that prayer was also allowed by the learned first appellate court. So what happened, Lordship, during pendency of the present appeal, in the month
This
of
IA is for what purpose?
for injunction.
Draft of injunction.
Yes, Lord.
So already this court has directed to maintain
Status quo, Lord. So that may be continued till this
That
school.
may be
Yes.
continued. Mr. Bhagwati. The RSA is ready for hearing.
It may take time. Because 2017 never.
Yes.
2012, 13 never presently going on.
No, this
Service is completed in the
service completed.
service completed.
Then let it be in the hearing column then. Any objection?
No.
Third, sir, your good name please?
R. Sharma.
R. Sharma, learned counsel for the applicant. And Mr. Bhagwati, learned counsel for the respondent of the parties. This interlocutory application which referred for grant of ad interim temporary injunction in RSA number 213 of 2017. It is submitted at the bar that by order dated 9/1/2023, this court was placed to direct the parties to maintain status quo as on 9/1/2023 till filing of the objection petition by the parties, by the opposite parties. It is further submitted that till disposal of the aforementioned RSA, being RSA number so and so, this interim order may be continued. Taking note of the submission order of both the parties, it is provided that interim order dated 9/1/2023 shall contain the disposal of the RSA number 213 of 2007. In terms of above, this IA stands closed. RSA, it is submitted that service in this appeal has already been completed and the LCR has also been received and the matter is ready for hearing. Accordingly, it is provided that the rest of the matter for hearing in usual courts.
Please, your lordship. My lord, this is regarding transfer of custody petition. Petition filed by husband and this petition filed for transfer by wife from Hailakandi to Hujai. My lord. Interim was granted, my lord. Stay was there. We have submitted it on 5/12/2023 therein. And the
Service completed or not?
my lord, as per the report I have seen, he has two addresses. One permanent is Hailakandi and he actually resides in Dimapur. We have given both the address with 3 mobile numbers, including his father. As per the handwritten report I have seen, the father refused to receive and 2 service steps were taken, one as usual and one is registered post. Registered post with AD has not returned, it is for a serve at Dimapur one. And from the district court, Dimapur, no report has come and both from Hailakandi returned. And a handwritten report is there, kindly have a look kindly to it, my lord, by the process server. That father refused. He rang to the candidate, the person, the husband, who told that he is in Dimapur and he is informed about the case. And another he copy received as per the postal ID from Dimapur.
The latest office note is dated 19th of March 2025.
My lord, one of the
So
backside.
in this office note, it is stated that petitioner is residing at Dimapur and therefore notice could not be served upon.
My lord, there are two steps, my lord. One normal course and with one registered post ID. And one is served, my lord. And one is served, I have seen in the reports, with registered post. One is served in Dimapur. And another is informed over telephone from Hailakandi or postman or process server. It is a handwritten, my lord, in the backside, my lord, of the copy, my lord. It is red marked also. Some underline is with red ink, my lord. Because mobile number was given. So twice my lord, he is informed. One is to register post with ID and another over telephone by the process server or postman perhaps, my lord. So maybe deemed to be served, my lord. A case is stayed, my lord, there. He knows it very well, my lord. Since 2023.
So he refused to accept the notice stating that the
By
person
father, by
concerned
father.
is not his son.
Sometimes he is notice son. Yes, also it is also said like. First he rang to father over, and my lord, register
Better
post is
you
served.
take a test instead of
My lord, register post is served. Kindly have a look, my lord. This office note, my lord. Two part. One is usual process report, and one report is on registered with AD. Kindly have a look this one, my lord. Two part of the report, my lord, office note, my lord.
that's all right. Which one is sir?
My lord, register post one.
Show me the.
It's okay. Your lordship is not found, my lord.
So. Next. After some time, you go through it. None appears for the petitioner on call or recital lays the matter after one item. Each of subsequent non-appearance, appropriate order shall follow.
17. I for the response.
You offer response. Oh, Mr. Hawk for
17.
May I please, Your
Yes.
Lordship, as per office note dated 19th March,
LCR is received and the sole respondent has entered into an appearance.
Matter is ready for hearing.
Ready for hearing.
Okay. Heard, Mr. Your good name, please.
TK Sharma.
Learned for the appellant and the for respondent. It is submitted at the bar that service already completed and the records from the learned trial court as well as past appellate court has been received and the matter is ready for hearing. And accordingly, it is provided that recital is the matter for hearing in usual course.
Good. As per the office noted, dated 19/3/25, respondent has filed Nama and appearing. Matter may be posted for admission hearing.
The part is completed. So we'll list the matter for admission hearing then.
And
both the parties are represented by the entities of the matter is ready for admission hearing. Accordingly, it is provided that rest of the matter.
Lordship,
Admission hearing after
interim order pass earlier may be continued.
after 2 weeks. After 2 weeks. Interim order pass order.
I pasted the flag, my lord. I pasted the flag, my lord. Office note.
That's why illegible signature. How can I be assume that the person concerned has received the notice? Effect. Yeah. That's for petition from which place to which place?
My lord,
From which place to which place?
and from Hailakandi to Hujai.
Right.
Hailakandi. He resides permanently in Dimapur, that is correct. That's why we taken, but he filed the case at Hailakandi only to harass the wife. Because he walk a distance, he could have filed in Dimapur because it's nearest to me. Or he could have filed Hujai, 2.5 hour journey for him from Dimapur.
Where you were residing?
My lord, we have separated twice, my lord. After once we separated, then some mutual agreement was there, then again separated. The details.
No, where you were staying now?
My lord, misbehavior, harassment, physical torture.
You are staying at which place now?
Is my parental house at Hujai.
Right.
Parental.
So the signature appears in the AD card is illegible.
If you lordship is so please, I can take step again.
Then what will
I can
happen?
step again, but same thing will repeat, my lord. But my lord, the order is stayed there. Court proceeding is stayed. He is well aware of, my lord. And in the hand note, my lord, it is written that he has telephoned him. He said that I am staying in Dimapur. In the handwritten, my lord, note, my lord. So he's twice informed, my lord. So as far as my opinion is, that is up to your lordship's opinion. If your lordship
So
says I
last
can,
time you take again step upon him.
my lord.
Third Mr. Talukar learned counsel to the petitioner. Office note dated 19/3/2025 indicates that notice issued to the AD card of the notice issued to the respondent returned with a report with illegible signature. And unserved notice issued to the respondent returned with a report addressee out of station returned to sender. And the report of the process server indicates that notice could not be served as the respondent is residing at Dimapur. And the said office note also indicates that notice issued to the respondent through the district institution, the Dimapur, Nagaland has not yet been received. There are taking note of above facts and circumstances, it is provided that the learned counsel for the petitioner shall take perspective upon respondent number upon the respondent by registered post with ADN, also by usual process within 1 week from today. Place the matter after 4 weeks.
My lord, interim stay may be continued.
Interim order, password itself.
Obliged. So in this case, my lord, for the office note dated 19/3/2025, service upon respondent 1, 2, and 3 is complete. And as regards respondent 4, he was a pro forma respondent.
She expired.
She expired. She may be stuck off for in regard for as regards this application. And the matter may be, I pray my lord be fixed for admission, my lord.
Third Mr. Town, learned counsel for the office note dated 19/3/2025 indicates that as per report of the process server, notice has been served upon the respondent number 1. The office note also indicates that notice issued to the respondent number 4 returned with a report addressee expired. Mr. Town submits that respondent number 4 is a pro forma respondent and he or her
She
and her name is struck off from the array of this petition. Where is accordingly allowed the post and edits of the petitioner. The name of the respondent number 4 is struck off by array of as service completed. Rest shall be done at the full admission hearing. After 1 week,
yes,
also
after 1 week.
after
Please, your lord.
Okay, this is an application under section 5 only, my lord. For consideration of delay, 9 days only, my lord. My lord, discrepancy in this case is this, my lord. The
9
appellate-
days delay.
My lord,
9 days.
9 days only.
What is the reason?
Reason, my lord, your lordship cannot see the memo of appeal, my lord. In the memo of appeal, my lord.
No. In which paragraph of this application you have mentioned?
My lord, delay has been derived from the memo of appeal, my lord. Certificate copy, my lord. I have obtained the certificate copy from the landed appellate court below. Wherein, my lord, they have not mentioned they have not filled up the three my lord, clauses of the certified copy.
So you could not obtain the certified copy in time. That is the reason.
No, my lord. I have obtained the certified copy in time, my lord. But my lord, in fact, your lordship, I cannot see the certified copy, my lord. It pays, my lord, 26.
No. In this application, where you have mentioned the reason?
Reason, my lord, I have mentioned, my lord. In paragraph 3, my lord. Paragraph 3, my lord. I had applied for the certified copy of impugned judgment and decree, my lord, on 18/5/23, my lord. The copy was provided to me on 3/6/23, my lord. But before providing the copy, my lord, there are two clauses. The date of notifying requisition is blank. Date of supply of notification is blank. In the certified copy, my lord. which ought to have been a date. In that view of the matter, my lord, delay has been accounted by the registry.
That's or not? Any objection?
Yes, my lord. Lordship will find the page 9 of the IA, my lord. Okay.
9 is the affidavit.
My lord, here Lordship will find the my lord name, my lord, Nilesh Agarwala, son of my lord late Durgalal Agarwala.
Son of
Durgalal Agarwala,
Durgalal.
page 9, my lord. Now Lordship will find the in the memo of appeal, my lord, page 74 is the my lord trial court judgment, my lord. Issue number 4. 74, my lord. Memo of appeal.
Page number 70.
4, my lord.
Yes.
Issue number 4, my lord. Whether Durgalal Agarwala has adopted the plaintiff number 1 as his son to legally valid adoption bill. Now Lordship will find the decision at page 79. Because 41 paragraph.
Negative.
This issue is decided negative in favor of the defendant counterclaim. Now Lordship will find the order at page 94.
Page number 94.
My lord.
Yes.
3, my lord. Deed of adoption of plaintiff number 1 is held ineffective, illegal, and inoperative in law. My lord, that my lord findings of the learned trial court, my lord, the plaintiff, my lord, the applicant wherein, my lord, has not challenged. That has attained finality. Now my humble submission is that, my lord, since the findings of the learned trial court, my lord, has not challenged by the plaintiff, or my lord, applicant hearing, my lord, before any forum or higher forum, my lord. So that has attained finality. Now the application filed before the honorable court by the applicant, being the son of the my lord Durgalal Agarwala, my lord, is not maintained.
That finding is not under challenge.
Not under challenge because appeal filed by me.
Yes.
My lord, there
You
is
are no longer the son of Durgalal.
no, my lord, there is other applicant too.
But the
There is
affidavit
other
I
applicant
have
too, my lord.
pointed out,
And my lord,
shown.
this has not been, my lord, this has not been challenged, my lord. Regarding the right granted by the trial court, my lord, in favor of applicant number 2, my lord, which has been set aside by the appellate court, my lord.
But affidavit is shown by the applicant number 1. I am the applicant,
Both are,
plaintiff number 1.
both are applicants, appellants, my lord. Both are applicants, applicant. And my lord, this is subject to a dispute of merit of the appeal, my lord.
But the maintainability,
My lord,
I have raised the objection.
that said question
That
may not
has
be,
not been, my lord.
may not be,
We will keep that question open.
that's my open, my lord.
But they have not
Only 9 days delay. Let us condone it. We will see.
This may be considered at the time of admission of appeal, my lord.
Third, Mr.
An alam.
Alum learned for the applicant. Then Mr. R. Sharma for response. With applicant, 5 of the applicants. Like it part. Repetition act related with order for the to take A of the state. It's preferred with the delay of preferring the connected regular second. Mr. Alam learned comes for the applicant subset. The reason for delay has been explained in paragraph number 3 of the application. And that the applicant had applied for the certificate copy on 18/5/2023, while the judgment was pronounced on 4/5/2023. And there is no lapse on the part of the applicant hearing. And the delay of 9 days is bona fide one. Therefore, it is compelled to allow this application the other so not. Learned for the respondent has opposed the petition on the ground that the learned trial court has recorded finding in the order the judgment and decree dated 4/5/2023 that the present applicant is not the son of like Dudala Ladura, and the same finding has not been challenged by the applicant. Taking note of the subsequent of the parties and also the explanation so forthcoming from the statement and environment made in paragraph number 3 of the application. This 14 claim to consent the delay of 9 days in filing the paper. In view of the order passed in this, I now the registered regular second appeal and this before the court as practical.
Memo of appeal. I'll finish. Memo of appeal.
Not part. Mr. Sorma learned submits that he is not part with the copy of the order. Mr. Alam undertaking to part is the same with Mr. Sorma. Reading the proof of the thing.
By tomorrow. By tomorrow.
By
21.
Much more.
Wait, this is a lordship. Lordship may take up I number 761763, which is an impediment application filed by the applicant.
My lord, the appellant. We don't have any objection if it I allowed.
No?
We don't have any objection.
No objection.
Yes.
Heard Miss
Virai.
learned counsel for the applicant and also heard Mr.
DM not.
Learned counsel for the respondent. This application is preferred by the applicant. Timothy Bonita Day for impeachment. As respondent number 2 in RERA appeal number 6 of 2020. Why is required to be implemented?
Lordship, the applicant is the necessary party as because she is the one who initiated the entire RERA complaint and proceeding before the RERA appellate. Entire RERA based on the yes, Lord.
The learned counsel for the applicant submits that it is the applicant on whose complaint the RERA proceeding was initiated, and as such it is a necessary party and are required to be implemented as respondent number 2 in the RERA appeal number 6 of 20. The learned counsel for the respondent submits that he has no objection in the event of allowing application. Third, taking note of the submission of learned counsel for both the parties and also considering the fact that the record in the application is allowed, the applicant hearing shall be included as respondent number 2 in RERA appeal number 6 of 2023. In view of the order passed in I number 7, now the counsel for the appellant shall file amended outside of the RERA appeal number 7 within a period of 1 week from today. Fine.
Lordship, a copy of the RERA appeal as well as the connected I may be served to us.
Okay. The learned
I
counsel
thought
for the applicant submits that the necessary direction may be given to the learned counsel for the appellant for providing copy of the IA along with the uh, RERA appeal memo of RERA appeal. The learned counsel for the appellant undertake to furnish the same. Today?
No, my lord, that amended copy will I furnish the amended copy.
Okay.
We will take.
Okay. After furnishing the amended memo of appeal. Within a period of 1 week.
Much obliged.
10:22.
May to the lordship.
Yes.
This case appeal has already been admitted and today is for consideration of the stay. Lordship, I want to file an additional affidavit in the stay matter, lordship, because some fact has not come and it is necessary for consideration of this stay, lordship. So I may be given 1 week time. I'll file the additional affidavit in that time.
Third, Mr.
R. Somal.
R. Sharma, learned counsel for the applicant, and Mr. Alok for the respondent. Mr. Sharma submits that he may be granted 1 week time to file an additional affidavit. There is accordingly allowed, rest shall let the matter after 1 week.
Yes, lordship. Some date may be fixed.
Others,
Convenient to my other place.
7 or 8 April.
7. Yes. 7.
Lordship, let it be on 8 April because some time may be required for hearing and it is a hearing day, lordship. So,
8-4.
8.
obliged.
Hey, please. See, during the pendency of this matter, lordship, respondent number 1B and respondent number 8 expired, lordship. Accordingly, lordship, we could not file the substitution on time. The matter accordingly went abated. Accordingly, lordship, 3 applications each we have filed. Continuation delay in setting aside amendment, setting aside amendment petition, and substitution petition.
Which is the delay petition?
Yes, lordship. Lordship may see IA
By number
number
3924.
694 of 2024, 694 IA. That's the substitution of respondent number 8, Jutika Das.
So first we have to condone the delay.
Yes, then lordship, 696 is the condemnation of delay in setting aside amendment. 696 of 24. Say delay of lordship, 648 days.
Oh, why 2 applications are there?
2 person died, lordship.
2 person.
2 person died. Jutika Das and one Asutosh Das.
Sarani Sharma.
Yes. Then condemnation of delay of Asutosh Das is 3924 of 24.
Third, Mr. Your good name, please.
CKS Borwa, lordship.
Who are for the respondent?
Number 1C.
1C. For rest of the respondent?
Not already not served, lordship. Notice served. Lordship may kindly see office
So
not
in
dated.
this second petition. In respect of death of Asutosh Das. Here notice has not been issued.
Pardon me, lordship. In Asutosh Das, lordship.
Yeah.
What petition, lordship?
This IA 3924.
3924 is condemnation of delay.
Yeah.
Then lordship setting then 3925 is substitution. There is lordship actually we have filed one other setting aside amendment is also there. I have not find that on record. Actually 3 applications. Condemnation of delay
No.
is 3924.
This 696.
696 is lordship in regard to Jutika Das, lordship.
Jutika Das.
Jutika Das.
Yes.
Yes.
Their notice has been served.
Notice earlier, the legal notice on the legal heirs which is supposed to enter, that notice has not been served yet. Otherwise, lordship, leaving Jutika Das, all the respondents' notice has been served as per office note dated 1/8/2023. Legal heirs of Jutika Das has not entered yet. Accordingly, notice could not be served, lordship. Otherwise, leaving aside these two dead person, all the name of all the respondents, the notice has been served. Office note dated 1/8/23.
So, Mr. Mandal, in IA number 696, you are supposed to obtain instruction. You are appearing for 1C.
1C.
Then on that day, you have submitted that you will obtain instruction in regards 1B.
1B.
No, 1B demise, suffer demise. In respect of 8A, 8B, 8C.
Eight A, 8B, 8C. I have already intimated to the respondent number 1C regarding this matter. I will again apply that.
Now you are appearing for 1C.
1C.
Otherwise, lordship can dispose of this IA, directing me to send notice to the newly implemented legal heirs of the deceased. That you can do, because the names has already been earlier. Mr. Mondo was directed to provide me the names of the legal heir, which was not in our hand. After that loss, subsequently we got in hold the names of the legal heir. They are in the application. Their names have been reflected. So what I pay, lordship may dispose of the IA and directing me to take fresh steps upon the legal heirs, lordship. That newly implemented the legal heirs.
Yes, Mr. Mandal. Any objection?
No.
Third picture, CKS
CKS
learned for the applicant and Mr. Mandal. Learned for the respondent 1C. This is IA number 696 of 2024. This interlocutory application is prepared by the applicant for condemnation of delay of 648 days in filing, setting aside abatement petition. So why the petition could not be filed in time?
Lordship, actually, lordship, the thing is that the reasons are actually mentioned here, lordship, could not file the application within period. Therefore,
Paragraph number?
Paragraph number 5, lordship. The petitioner came to know about the date of the respondent number 8 only on 28/8/2003.
Okay. The learned counsel for the applicant submits that the application could not be filed in time as the petition, as the applicant came to know about the date of respondent number 8 only on 28/8/2023. And thereafter he inquired and collected the names and address of the legal heirs of the deceased respondent number 8 only on 31/8/2023. And therefore, the application could not be prepared in time. Then the delay is not intentional, rather it is circumstantial, therefore it is contented to conduct as a Mr. Mandal, learned counsel for the respondent number 1C submits that he has no objection statement of allowing this application. Whereas taking note of the submission of learned advocates of both the parties, this interlocutory application stands allowed. delay of 648 days in filing, setting aside abatement petition steps. Undone. And thereafter is 3924.
Yes, 3924 is in regard of Asutosh Das.
Yes.
Delay of 2043 days. The reasons has been explained in para number 5.
Mr. Mondal, you are for this newly implemented respondent. No, in this application, you are for
No, he's for 1C only.
1C only.
okay.
He's for 1C only.
No, in this IA,
The legal heirs has not entered appearance because notice has been not went to them. If lordship.
so we have to issue notice here.
Yes, fresh notice.
Or Mr. CK Solva, learned from this application under section 5 of the Limitation Act. Related section 151 of the Code of Civil Procedure is prepared by the applicant for consideration of delay of 243 days in filing, setting aside abatement petition. Respect of date of the Asutosh Das. He is 1A, respondent number 1A.
Asutosh Das is respondent number 1B.
Come to page number 2.
Yes, 1B. 1A was the wife, Hiranmani Devi of Ananda Mohan Das. She expired. Asutosh Das was the first son. So 1B, so Asutosh Das expired. 1A was the Hiranmani who was the wife of late Ananda Mohan Das. She already expired long ago. Her legal heirs, Asutosh Das was the first son. Asutosh Das subsequently died. Now we are here for the legal.
Asutosh Das?
Yes.
But here 1A, you mention it as 1A in the application.
But in my distinct, in the IA lordship.
Yeah.
Lordship, what has happened, Lordship, as this thing, because Asutosh Das wife expired long ago, because this application is a fresh application, so we cannot implement the dead person name in a fresh application. That is the reason, Lordship, from 1B it has gone to 1A. So now, while reflecting in the order, it has to be 1A, Lord.
1A. Issue notice to the response. Returnable forex that be taken by register to 88. And 3925.
3925 is the substitution, Lordship. These are the legal heirs of Asutosh Das. My prayer is to substitute them in place of their father's name. Because Aditi Das is the wife of Asutosh Das, Abhijit Das is the son, and Joyce Das is the daughter.
Yes, so Mr. Mondal. Yeah.
First substitute, then notice. First substitute, then notice, Lordship.
Yes. Part Mr. CK Solva, learned for the public Mondal, learned from this application order 22-4, related section 151 of the Code of Civil Procedure. Referred by the applicant for substitution. The legal heirs of this is respondent number 1B. The Asutosh Das. in RSA number 161 of 2011. The learned counsel for the applicant submits that Asutosh Das died on
Died on 5/7/2017.
5/7/2017. And his legal heirs are required to be impleted here in this. Required to be impleted in the RSA number 161 of 2011. And as such, this application may be allowed and notice may be issued to the newly impleted respondent. As a Mandal learned counsel, the respondent submits that notice may be issued to the newly impleted. Taking note of the submission of learned counsel for both the parties. This interlocutory application stands allowed the legal heirs of Sri Asutosh Das, respondent number 1B, Sri Asutosh Das, be impleted in the RSA number 161 of 2011. And notice be issued to them may be returnable within 4 weeks. But be taken by the appropriate ADM process within 1 week from today. So this IA closed.
Yes. I think 694 is there, Lordship. Lordship has to substitute the legal heirs of Jutika Das, 694.
That is the number?
694, Lordship. 694 of 2024. Jutika Das legal heirs has not been substituted yet, Lordship. Although Lordship has issued notice.
RS1 here. Whether notice was served here?
No, notice that because the legal heirs has not been made impleted yet. Accordingly, no notice has been served. So my prayer is that to substitute them, then face notice will go to them. Lordship. Just like the legal heirs of Asutosh Das. They have not been made party here, Lordship. That is the reason we have face
So
notice.
then why notice was issued? To come to order dated 13/5/2024.
Then Lordship had missed the part. But I think Lordship, the legal heirs has not been made party, not been impleted in place of Asutosh Das.
If see this order,
With
13/5.
Now, one chance may be given, I will take the notice. itu apa namanya notice lo pada itu mau lo itu. I'll take the notice upon the.
The learned counsel for the applicant submits that he will take step upon the response. Accordingly, it is provided that it's be taken by registered post with ATM of the T working days from today.
Masuk.
Please, Your Lordship, so this is an application for early hearing of the matter, my lord. It's a concurrent finding against which I am for the respondent, my lord. The appellant has preferred this appeal. My lord, it's against concurrent finding of facts, my lord. Petition is about 80 years old now, my lord, and is not keeping good health, my lord. Therefore, my lord, he's praying for an early hearing of the matter, so that before, my lord, he wants to see the matter settled, my lord, before, my lord.
What do you want?
I'm praying for an early hearing of the matter, my lord. Lordship may fix it sometimes in the after Bihu or in the month of May, my lord.
Sahab. Or Mr. Dr. Learned Counsel for the applicant, Mr. Hawk for the respondent. This application under section 151 of the Code of Civil Procedure is referred for early hearing. The Dr. Learned Counsel for the applicant submits that the applicants are
One applicant.
applicant number.
My lord, he's the sole respondent, my lord, and the applicant, my lord, here. Others, my lord, are the appellants, my
The
lord.
applicant is the respondent in RSA number
My lord.
195 of 2023. And he is a person. And as such, there is a requirement for early hearing of the RSA number 195 of 2023. Mr. Hawk submits that he has no objection in the event of allowing this application. Accordingly, taking note of the submission of further applicant of website, provided that let's submit the matter on
In the month of May, my lord.
1st of May.
My deeply obliged, Your Lordship.
I close.
Deeply obliged.
Sir, I filed the IA number 133, 2025.
For
IA.
for
For just actually, the Honorable Cole already directed to file before the hearing any application, just the Honorable Cole be given the ability.
for early hearing.
Your.
Early hearing.
Totally.
When do you want? Second of May. June.
So June is very
Or
long time.
May.
It's possible to fix and
Heard,
within
Mr. Your good name, please.
R.A. Romay.
R.A. Rongmai, learned counsel for the applicant, and Madam for respondent. This application under section 151 of the Code of Civil Procedure is referred by the applicant for early hearing of RSA number 32 of 2023. After hearing learned advocates of both sides, it is provided that registration leads the matter on 6th of May. 6th of In terms of this ISS closed. 6th of May.
27.
Market in the IA service is awaited, Lord.
Service awaited. Heard means
S. Todi, Lord.
learned counsel for the applicant. Office note dated 19/3/2025 indicates that service upon
Sole respondent.
sole respondent is awaited. Accordingly, it is provided that restitution is the matter after 2 weeks awaiting service report upon sole respondent.
Obliged, Lord.
28.
Here I have from the, for the respondent matter. Actually, they have filed a petition for withdrawal.
For?
Withdrawal. With the liberty to refile a fresh petition matter. That is, it is 175.
But whether the applicant is present today?
But they are not.
Applicant. None appears for the applicant on call. How Mr. Ad hoc?
Actually, they are
the
the,
respondent present.
what happened, madam, in the meantime, respondent number 1 expired. The last copy that my lord ordered dated 16/10/2023 in IA 1733. I was asked to furnish the particulars of the respondent number 1. And accordingly, I have filed the IA furnishing the particulars of the behavior of the respondent number.
Let the applicant come
Let them come, my lord, otherwise.
after 1 week. Let the legislature after 1 week. In the event of subsequent non-appearance, non-representation, appropriate order shall follow.
Defendant number 5 expired, my lord. I filed substitution petition, my lord, as well as condonation of delay of 197 days and setting aside abatement.
Any objection?
My lord, here are two complicated things. One is number 4 has also died.
My lord, that I don't have knowledge, my lord, that I have to take again file fresh.
Died. Application. I have no objection to that. They may even now file application for it. But my lord, it was in fact a suit under the Assam Urban Areas Rainfall Project. So after dismissal of the first appeal against the P3, as per section 9, that is not maintainable at all because that section has provided for finality of the dispute. In that sense, lordship, what happens if no second appeal lies, revision lies. So it is arrest in one sense. Present application before your lordship is the arrest.
RSA and it is not maintainable.
My
Yes,
lord,
lordship.
regarding maintainability, my lord, my senior will submit, my lord, today.
I am not getting it on today itself.
The matter may be
I
adjourned.
am just praying before your lordship just to have a hearing on the point of maintainability first. The question of substitution will come if the very application is RSA is maintainable. Yes, lord.
Yes,
Otherwise,
usually this revision petition is fine.
Regarding maintainability, my lord, I have to.
Who is your senior?
KK today he is not there, my lord.
today he is not
Pardon?
KK day, my lord. It may the matter may come after 2 weeks, my lord. Regarding maintainability. 1 week, well, anyway.
on that point, 2 weeks or 1 week, I have not. But so far, this
Maintainability.
Yes, lordship, that is a very serious thing. One thing, lordship, I will just apprise before your lordship on one point. Against that decree before for which the application RSA is made before your lordship, a writ application was filed. When writ appeal filed or not, that is not on record. SLP was filed in the Supreme Court. These are all perverse course we have taken. So this is how the delay has been there. The delay has been ultimately means lordship at the time of the hearing, initial hearing, delay has been condoned on payment of cost of rupees 6,000. It was on lordship 26/3/2009. That has also been perhaps not paid as yet.
My lord, that regarding the payment of cost, my lord. Actually, we are newly implemented, my lord,
That is what that
council, my lord. My lord, some earlier advocates were appearing, my lord. 2 weeks.
No, if there is bar in admitting the regular second appeal, you file the revision petition.
No,
they withdraw this petition.
No, that my senior will, my lord. Only 1 week may be granted, my lord. Today matter may be adjourned, my lord.
Okay, we will not pass any order in this IA then.
Lordship.
Heard, Mr.
VK Bora, my lord.
Learned counsel for the applicant and myself, Mr. L. Tagokar, learned counsel for the respondent. List the matter after 1 week.
Lordship.
It was not admitted also because
yes.
RSA is to be admitted, lordship, substantial question has to be, that has not been done.
It will come after 1 week.
Lordship.
So you discuss the matter with your senior, and if it is not legally admissible, withdraw it then file revision.
Lordship, that's, I have to take instruction, my lord. Highly obliged, Lordship.
Lordship, we have filed our petition, order 41, rule 27. A copy has been already served upon them.
I'm appearing on behalf of Mr. P. I've been asked to pay for 2 weeks and file our objection.
Lord,
Okay. Third, Mr. Bhagavati, learned counsel for the applicant, Mr. T. Day. Learned counsel appearing on behalf of Mr. AC Day. TC Day. TC Day. This application under order 41, rule 27. Deal with section 151 of the Code of Civil Procedure is required by the appellant for production of additional evidence before court. Do you receive the copy? Yes, sir. The learned counsel appearing on behalf of Mr. PC Day submits that he may be granted some time to file objection. Here is according to law. This is the matter. After 2 weeks or 1 week? 2 weeks.
May I please, your Lordship? This is an application, interlocutory application, your Lordship, before your Lordship, under order 22 of P of CPC for substitution of legal heirs, your Lordship. And the appellant number 1, Nur Muhammad, died on 22/11/2024, and his legal heirs, there are 3 legal heirs of him. 3 sons, there is Sekandar Ali, Hanif Ali, and Ali Akbar.
They are required to be impleted.
Lordship.
They are required to be impleted.
Lordship.
Okay. Yes, any objection? No objection. Third, Mr. Your good name?
S. Hussain.
S. Hussain.
Lordship.
Learned counsel for the applicant and Mr. SI Talukdar, learned counsel for the respondent. This interlocutory application under order 22 rule 3 CPC is referred for substitution of legal heirs of appellant number 1 Nur Muhammad in
RSA number 22 of
RSA number
22 of
2012 who suffered demise on 22nd of November 2024. The learned counsel for the applicant submits that appellant number 1 Nur Muhammad died on 22nd of November 2024, leaving behind 3 legal heirs, namely Sikandar Ali, Hanif Ali, and Ali Akbar.
Lordship.
And the aforementioned legal heirs are required to be impleted as party in the RSA number 22 of 2012 in place of appellant number 1 Nur Muhammad. The learned counsel for the respondent submits that he has no objection in the event of allowing this application. Further, taking note of the submission of learned counsel for both the parties, this interlocutory application stands allowed. Legal heirs of appellant number 1 Nur Muhammad be impleted in RSN number 22 of 2012. Whereas in view of the order passed in this IA number 595 of 2025, the counsel for the appellant shall file amended post title of the RSN number 22 of 2012 within a period of 1 week from today.
32.
May it be the right. I have filed substitution application, Lordship. There is a delay, so there is a condonation application and setting aside abatement. Your Lordship will first take up IA civil number 653, Lordship.
Yes.
There is a delay of 88 days, Lordship, in substituting the disease respondent number 1.
Let notice go at this.
They are appearing, Lordship. Respondent.
You are appearing. So any objection? No objection. Third Ms. R. Chaudhary, learned counsel for the applicant and madam. Your good name, please. Yes. That took the learned counsel for the respondents. This interlocutory application under section 5 of the Limitation Act is part for condonation of delay of 88 days in substituting the deceased respondent number 1, substituting the legal heirs of deceased respondent number 1 in RSA number 123 of 2010. The learned counsel for the applicant submitted
In paragraph 4, I have stated.
respondent number 1 in RSA number 123 of 2010 suffered demise
On Lordship 3/9/2024.
3/9/2024, leaving behind his legal heirs and there is delay of 88 days in filing the petition, substitution petition. And therefore it is contented to conduct the same. The learned counsel could have responded that there is no objection in the event of condonation of delay of 88 days in filing the substitution petition. Taking note of the submission of learned counsel for both the parties, this court is inclined to allow this application. Delay of 88 days in filing substitution of deceased respondent number 1. Legal heirs of the deceased respondent number 1 is hereby condoned.
Then your Lordship, IA civil number 654 for setting aside debit. Now IA civil 655 for substitution. In para 3, I have mentioned the name of legal heir. Page 6.
Third is also very learned counsel for the applicant. Is the Gupta for the response. This application under order 22, rule 4 of the Code of Civil Procedure is filed by the applicant for substitution of deceased legal heirs of the deceased respondent number 1 RSA number 120. Learned counsel for the applicant submits that respondent number 1 died on
Lordship 3/9/2024, paragraph 5.
3/9/2024, leaving behind 5 respondents, namely Pinky Bhomik, Pinky Bhawal, Sumki Das, Mausami Dev, and Lovely Pal Dev. And they are required to be included in the RSA number, required to be substituted in place of the deceased respondent number 1 in RSA number 123 of 2010. The learned counsel for the respondent submits that there is no objection in the event of allowing this application. Further, taking note of the submission of learned counsel for both the parties, the court is inclined to allow this application. The names of legal heirs of deceased respondent shall be substituted in RSA number 123 of 2010. Review of order passed in high numbers. Now the learned counsel for the appellant will file amended first title within a period of 1 week from today.
Lordship, before that, one more IA is there, IA civil number 657, Lordship, for disease respondent number 2. My learned friend has filed one interlocutory application, Lordship, informing this court that respondent number 1 and 2 died. So accordingly, we have filed application. Respondent number 2 died on Lordship 1/1/25, and this application was filed on 17/2/25. So within the period of limitation. In this case, there is no delay, Lordship. The name of legal heirs mentioned in
Is
page
are
6.
totally learned counsel for the applicant and Ms. Dasgupta for the respondent. This application under order 22. Rule 4 of the Code of Civil Procedure is preferred by the applicant for substitution of the legal heirs of deceased respondent number 2 in RSA number 123 of 2010. The learned counsel for the applicant submits that this respondent number 2 suffered demise on when
1/1/25, 2025.
1/1/25, leaving behind
Page 6.
Rajan Dev,
Rajan Dev and
Rajan
Soma
Dev
Dev.
and one Soma Dev, and they are required to be substituted in the RSA number 123 of 2012.
2010.
2010. 2010. The learned counsel for the respondent comments that she has no objection in the event of allowing subject. They are taking note of the submission of learned advocate for both the parties with certificate application and allowed. The next up, legal heirs of respondent number 2 is substituted in the RSA number 123 of 2010. In view of the order passed in by number 7, so the learned counsel for the appellant shall file amended proceed in 1 week from today.
Lordship, in RSA, appellant number 1, 2, 3 already died, Lordship. So I am praying for striking out the name of appellant number 1, 2, and 3. So
Which
Lordship,
matter?
thereafter I will file amended.
Which matter?
In this matter, Lordship, in appeal, I am praying for striking out the name of appellant number 1, 2, and 3.
Where is the application?
Lordship, no application. I am verbally praying before your Lordship for striking out the name of appellant number 1, 2, and 3.
Yes, madam, any objection? Part is already learned counsel for the appellant. The RSA 123 of 2010, and also Hart is Dasgupta learned counsel for the is already learned counsel for the appellant submits that appellant number
1, 2, and 3. Lordship, 1 Jitendra Dev, Dojendra Dev, and
appellant
Ravindra Dev.
number 1, 2, and 3.
Yes, Lord.
Namely, Jitendra Dev, Dojendra Dev, and Ravindra Dev suffered demise on
Lordship, dates not available. They instructed me to strike out the name of these appellants.
suffered demise, and their names are required to be struck out from the array of this appeal. The learned counsel for the respondent comments that she has no objection to the event of striking out the name of the aforementioned appellant from the array of this appeal. We are taking note of the submission of learned advocates of both sides. The peer is thence allowed. The name of appellant number 1, Jitendra Dev, 2, Jitendra Dev, 3, Ravindra Dev, be struck out from the array of this appeal at the cost and risk of the appellants, remaining of the remaining appellant.
Now, Lordship, I will file the amended prospectus.
Accordingly, the learned counsel for the appellant shall file amended prospectus.
Obliged.
In 1 week from
I'll be filing my wakalatnama on behalf of the impeded. Obliged.
33 and 34.
learned counsel for the respondent submits that she will file wakalatnama for the newly impeded respondents within one week from today. Yes.
Lordship, on 4/2/2025, the learned advocate for the respondent had supplied a copy filed under Order 22 Rule 10A, informing that the respondent number 1 Roman 2 had died. So immediately that has been registered as IA civil case number 451, Lordship. 451.
IA number?
451, that is petition under Order 22 Rule 10A, Lordship. And that was filed by the respondents, Lordship, informing that the respondent number 1 Roman 2 had died.
Third is your good name, please. P. Sharma, learned counsel for the applicant, Mr. R. Sharma.
Yes.
Learned counsel for the respondent. This application under Order 22
Lordship.
to 10A.
Lordship, I am for the appellant and my learned advocate for the respondent. And being the
Who
advocate
filed
for
this application?
the
451.
respondent side, the respondent side has filed.
Yes, see, I am dictating that she is applicant here.
Appellant.
Yes. Rule 10A and Rule 11 of the Code of Civil Procedure is preferred by the applicant. Informing that informing the date of respondent number 1A, 1 Roman 2.
Roman.
1 Roman 2, namely Orob Polita, for giving notice to the appellant for their necessary action. Mr. R. Sharma, learned counsel for the applicant, no, appellant submits that he has already filed 2 IA.
3 IAs.
3 IA.
Yes.
Being
After-
IA
after-
number
IA
669
749.
of 2025, 750 of 2025. And the other one?
Lordship 750, 750, 669 and 749.
And 749 of 2025.
749 is under section 5, Lordship. So there is delay of 20 days in filing the petition for setting aside appellant.
Since step has already been taken by the learned counsel for the appellant by filing interlocutory application, this IA number 451 of 2025 stands closed. So 669. What is the pair here?
Pair for setting aside abatement, Lord. And 749 is section 5.
Third, Mr. R. Sharma, learned counsel for the appellant and Madam for the respondent. This application under section 5 of the Limitation Act is preferred for consideration of delay of 21 days in filing petition under Order 22 Rule 9 of the Code of Civil Procedure for setting aside abatement of RSA number 81 of 2015 as against the deceased respondent number 1 certificate Roman 2. The learned counsel for the appellant submits that respondent number 1 to suffer demise on
24/8/2024.
24/8/2024.
2024.
24/8/2024. And as such, the abatement of the RSA against the aforementioned deceased respondent is required to be set aside. The learned counsel for the respondent submits that she has no objection in the event of allowing this application. Taking note of the submission of learned counsel for both the parties. Abatement of the RSA number 81 of 2015 against the deceased respondent number 1, certificate 212, set aside. RSA 669. This is for
Setting as for prayer for setting aside abatement. The earlier one was for Section 5 Limitation Act for setting aside abatement. 749 was for delay condonation petition for setting aside abatement.
Seven 14. Seven 14.
RSA 81. Next. Next 669, Lord.
Third is a formal learned counsel for the applicant and madam for the respondent. This interlocutory application under order 22 rule 9 of the Civil Procedure is preferred for setting aside abatement as against the deceased respondent number 1, certificate 2, namely let Arup Kolita in RSA number 81 of 2015. The learned counsel for the applicant submits that this is submits that respondent number 1, 2, suffered demise on
24/8,
24/8, 2024. And there is a requirement for setting aside the abatement as against the deceased respondent number 1. The learned counsel for the respondent submits that she has no objection to the event of allowing the application. Further taking note of the submission of learned advocate for both the parties. Abatement of the RSA number 81 of 2015 against deceased respondent number 1, certificate 212, stand set aside. In terms of above this, IA stands closed. And 750. This is for
Substitution of the legal heirs of deceased defendant number 1, Roman.
Third, Mr. Arsorno, learned counsel for the applicant, and Ms. Suritsu, learned counsel. This application under Order 22 Rule 4 of the Code of Civil Procedure referred by the applicant for subsequent legal heirs of this is respondent number 1, certificate Roman 2. learned counsel for the applicant submits that the respondent number 1, 2, namely Aurum Polita, died on 24/8/2024, leaving behind two legal heirs, namely Timothy Monmi Borua Polita, wife, and Nilan Polita, minor son. And in the place of and in his place, the aforementioned legal heirs are required to be substituted in RSA number 81 of 2000. Taking note of the learned document for the respondent submits that he has no objection in the event of substitution of the legal heir of respondent number 1, 2. Taking note of the submission of learned document for the parties. This court is inclined to allow this application. The names of legal heirs of respondent number 1, 2 will substitute in the RSA number 81 of 2015. In view of the order passed in this I, now the appellant shall file amended cost title in RSA number 81 of 2015 within a period of 1 week from today.
May I please, Your Lordship? Lordship, FAO was filed challenging impugn order dated 23/9/2024 passed by the Civil Judge Senior Division, Darang. In filing this FAO, there was a delay of 45 days, for which we have filed an IA bearing number 801/2025. The said delay is particularly detailed in page number 4.
There is 45 days delay.
Yes.
Okay, let notice go ahead. Pardon, sir.
W. Hawk.
W.
Hawk.
Learned counsel for the applicant. This interlocutory application under section 5 of the Petition Act 1963 is referred by the applicant for confirmation of delay of 45 days in referring connected FAO under Order 43 Rule 1 of the R. Read section 151 of the Code of Civil Procedure. Against the order dated 23rd September 2024, passed by the learned civil the Senior Division Darang, although in Nijay case number 30 of 2023, arising out of title number 36 of 2020. Let notice be issued to the respondents, returnable in 4 weeks. They be taken by registered post with ADN in the process. Please after 4 weeks.
Oblige you.
May I please, Lordship? Mr. A.K. Gupta is another court. Kindly pass over for time being.
So, we'll issue notice. There is delay of 93 days. Heard me, sir, your good name?
R.K. Mohondo.
R.K. Mohondo, learned counsel appearing on behalf of Mr. A.K. Gupta, learned counsel for the applicant. This interlocutory application under section 5 of the Limitation Act 1963 is referred by the applicant for condonation of delay of 93 days in filing MSc appeal against the judgment and award dated
on 8/24.
21/8/2023, passed by the learned member of which court? MSCT, Tinsukia.
I am
Let notice be issued to the respondent, returnable in 4 weeks. They be taken by registered books with AD and also by usual process within a List after 4 weeks.
Thirty-eight.
So if the case is listed for the first time, in this
30
case,
days.
first time,
30 days.
30 days. No, 83 days delay.
But what you have mentioned in your application?
There was 83 days delay.
Pardon?
83 days delay in filing the appeal.
Are you sure?
No, Lordship.
Please go through this. I
39.
Like,
Lordship, Lordship, we have filed the IA for delay contingency. Delay of 127 days.
heard me, sir?
Yes, Kathak. Notice may be served, Lordship.
Okay. After 4 weeks. Next.
40.
None appears for the applicant on call, leaves the matter after 1 week. In the event of subsequent non-representation, appropriate order shall follow.
41 for hearing.
So why this matter is fixed today? Today is only motion day.
It was ordered on 2nd to 2025. There is an order of.
Actually, this is 2023 matter. Generally, it comes usually.
No,
On
my
the request of a learned friend, it was listed. Then it is coming day by day.
Because
Let it be on a hearing day.
response number 1 is on deathbed, my lord.
His sons are party.
No, my.
All his sons are.
And the matter is, they have judgment of concurrent finding.
Yes, it has been admitted.
Maybe.
It has been admitted in a substantial question law.
So suggested that
It may come after
Hearing
view,
day.
Lordship. After view.
No, my lord, third April, Thursday.
It may come after view, Lordship. 23 matter. There is
3rd April already lot of matters have been fixed. Let it be after we have
Then 24th April.
24th April. Okay. This agreed by learned advocates of both the parties. The SSL is the matter on 24th of April.
Timing
Obliged.
38. Okay. Lordship, with your permission, Your Lordship, I beg to mention 48. And this honorable court point out me to the annex page 2 of that order. I apologize that annexer 6 is page 54. That is there, Your Lordship. Annexer 6, page 54. That order that miscase J, the order which this honorable court pointed at me, that is on 16/12/2013. It is there, Your Lordship. I beg to apologize that out of sight, I could not pinpoint. Page 54, annexer 6.
Annexer?
Annexer 6, page 54. Orders are same, but date is little bit different. That is the point. Otherwise, it is there. Your Lordship. Page 54, Annexer 6.
Now this order dated 22nd of
That is
December
mistake.
2023.
There is invalid mistake, Your Lordship.
File correction petition.
Annexer 6 is the same, Your Lordship.
Maybe.
I'll file today. The date has already been fixed on Wednesday.
None appears for the applicant for the residential examiner. When that is fixed.
29 year lordship. So Wednesday, 27 is the date, lordship. I'll file today itself. Deep level. Lordship. 26 likes, na?